Waiting instructions, Lordship. I've taken the consent, Lordship.
RTA. Who is there?
Lordship. My friend,
Ah. What further information do you want?
Lordship.
What further information do you want? The agreement has been given to you.
Lordship, a part only. I am seeking from the date of inception. And also other points, regarding other points, they have not mentioned anything. I am challenging the.
No, the order of the Second Appellate Authority Commission is to the extent that you must be given that agreement. That agreement has been given to you.
Yes.
Yes.
Now, what further information do you want? And those information have been held already to be beyond. So you'll have to establish that this is within the, it's not covered by the exception clauses.
Lordship, one thing is that in my original application, not only agreement, some other information I sought.
I know they have indicated that, saying that this is beyond, because this is covered by the exception clause, they are not giving it to you.
Yes.
So satisfy us that this is not covered by the exception clause, we'll allow it.
No, Lordship, one thing is that section 10 cannot be utilized by the Central Information Commission. That it was used. How they can use it?
It can be used. Can it be used by the NRL? Can it be used by the NRL, SPIO, NRL?
Yes, Lordship.
It can be used.
He can be used. He did not use it, but Central Information Commission use it. How can he?
Okay, let it reach. We'll see.
Yes.
We'll see. If there is something which is there, information is to be given, you will have to give.
Let him file the affidavit. Lordship.
If they are not interested, what can I do?
Lordship.
24 matter. Okay.
Yes.
Heard Mr. Nayan Muni Hazurika, petitioner in person, as well as Mr. S.S. Roy, learned counsel appearing for the respondents number 1 and 2.
All the
Also, Mr. Roy submits that he requires a further 3 weeks' time to bring on record the stand of the respondents represented by him in the matter by way of filing an affidavit. Also, prayer accepted. Registry to list these matters again after 3 weeks.
All right.
Here it is, Your Lordship. My lord, I beg apology, my lord. It's a 2015 matter, item 14. Extreme personal difficulties only next week, my lord. Any date, Your Lordship, my lord. Only my personal difficulties.
Next week, I'm not there. Some file paper.
Well, I have taken consent, my friend. Only I have to leave the court, my lord. So any date, Your Lordship.
My lord, I am ready, my lord. My lord.
I don't know. Item number 14, sorry.
14.
14, sorry, 14. Oh, that matter.
Yes, my lord. When Your Lordship, my lord.
Heard Mr. A.K. Hussain, learned counsel for the respondents number 1, bracketed 1 and 1 bracketed 2. Also heard Mr. G. Gusam, learned counsel appearing for the petitioners. So, Mr. Hussain submits that on account of certain personal inconvenience, he is not in a position to argue the matter today. Also, the said prayer is not objected to by Mr. G. Gusam. Also, in view of the above, registry to list these matters again on 27/8/2024. Also, the matter would not be construed as a part-heard item any further.
My lord, may be taken as part. My lord, it may be kept as part of my lord.
I'm not here.
Hello.
He has expressed certain personal inconvenience. Otherwise, I would not have permitted it. Right?
No, my lord, I
Can't help
I
it.
did not
yes,
pay.
part heard, my lord. Lordship has heard him. That is,
I was ready.
well, I am also with you.
He has lost out.
Yes.
Don't worry. I was against you.
Well, I have to leave the court. That's it.
Please do so.
Well, I leave.
May I please your lordship, I beg to mention item number 19 to 22. Lordship, some accommodation.
Why is this matters listed? Last time also I had heard the matter. Thereafter,
Yes,
you
lordship,
tell me when you want it.
Any day
29,
next
30. No, I'm not going to do it. Because nobody appears in this matter. Last time also nobody had appeared.
lordship.
Mr.
last
Saraf
occasion
had made his
another
submissions.
Yes,
I had kept it for your part.
yes, lordship.
Then I had released it from Pathar.
No, lordship may keep it.
I'll not keep it.
Any convenient date, lordship.
No, you tell me a date.
Lordship, as and when lordship is.
I'm not here. Don't forget me. It's the bench. When you want it? Next week?
Next week,
Give me a
any
date.
date, lordship.
Give me a date.
Next week, Dr. Sarab is not available here also.
Whenever you fix a date. You
29.
agree upon a date on the prayer of Mr. B. Chaudhary, Learned Counsel for the Finance and Taxation Department, and this who submits that the submits for an accommodation for the day in the matter. So this said prayer is not objected to by the Learned Counsel for the petitioners. So as agreed to by the parties, raised it to list this matters again on date. You give a date, he'll fix it.
Lordship, we have completed our part.
Huh?
From our part, we have completed, Lordship. Just respondent.
I'm not hearing this matter. I've released it from Pathar last date. When both are agreeable to do the case, come, we will hear it. Small issue.
Yes, 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 Lordship.
Whenever it's convenient, Mr. Chaudhary, you give a date. Both of you give a date.
Yes, ma'am.
Next, Lordship, I beg to mention item number 6, my lord. I have required little bit accommodation at 2, my lord.
Look,
May I please your lordship? Lordship, I beg to mention item number 23 of the daily list, lordship. Lordship, in item number 23, we have filed an affidavit, but that affidavit has not been tagged with the record, lordship. The affidavit may be called for, lordship.
My lord, I beg to mention item 38, my lord.
30?
38. My lord, it may come up next week, my lord.
What is left here, madam?
My lord, the file has been misplaced, my lord.
By the second file to
My
deal.
lord,
Have the second file. Why keep this matter pending? Be here. We'll see what can we do. You had raised a particular point. They have now clarified that. You have not filed any affidavit thereafter. Matter of 22. Just lying like that.
My lord, the file of Mr. My lord, the learned senior counsel, Mr. S. Dotto, my lord, that also is misplaced, my lord. So, my lord,
Dotto is appearing for the respondents.
Chief Dotto, my lord.
See that
Yes.
construction thing, the permission, they have brought on record that how can we, that's the provision of law. How can we go against the provision of law when there is no power of condonation? You want to reduce the size of the height of your ground floor to a particular level. That is not permissible.
Yes, my lord, they have filed.
And you have not filed a reply.
I will file my reply, my lord.
This affidavit was filed long back, madam. What can you develop? Okay. On the prayer of Ms. S.B. Chaudhary, Learned Counsel appearing for the petitioner. Registry to list this matters again on 38/2024.
May I please, Your Lordship? My friend has mentioned earlier 23, item 23. They have filed the affidavit, but just now I got the copy, Your Lordship. So,
You are appearing for the petitioner.
yes,
Mr. N.N. Upadhyay, Learned Counsel for the petitioner submits that the respondent number 3. Respondent number 3. Respondent number
respondent 3.
has filed an
Oh,
affidavit
they
in the
don't-
matter, a copy of which was served upon him today. Accordingly, he prays for 2 weeks' time to
Yes.
bring on record the rejoinder thereto. Was a prayer accepted? Registry to list this matters again on 29/2024.
29.
29. Yes,
Mention item number 45, your lordship. Lordship, in this matter, I am appearing on behalf of Water Resource Department, your lordship, and we are directed to file one affidavit, your lordship. by-
long back, very, very long back. Long back you were directed
On 19/7, your lordship. Lordship,
on the prayer of Miss S. Deka, Learned Council for, you are appearing for
for Water Resource Department.
Standing Council, Water Resources Departments. You have informed the petitioner. Prays for an accommodation. Or prays for an adjournment of the matter by 2 weeks to facilitate filing of the affidavit by the said respondent. On behalf of the said respondent. The prayer is not objected to by the Learned Council for the petitioner. So matter stands adjourned. Registered to list this matters after 2 weeks on a date to be fixed by it.
Lordship.
May it please the lordship. Lordship, I'd like to mention item number 8, 9, and 10 for adjournment, lordship. Lordship, we have been engaged yesterday. We have filed a wakalat. My lordship, could it be adjourned for the day?
I'm sorry, we are not, we are adjourning it.
Lordship,
What
we
is
have been-
this?
Lordship-
Every day you come up with a new plea. If you don't want this court to hear the matter, please tell it. This is the third time this is happening.
Lordship, we have been engaged yesterday.
I don't know.
lordship.
You argue. We have heard this matter. It was made CAV. Then it was for delivery of orders. A mention is made on behalf of Mr. Chamua that this matter be not taken. If there is a development, we'll file an affidavit.
Lordship, there is an affidavit also which was filed yesterday.
Bring it on record, we'll see. If you can file the affidavit, why can't you argue the matter?
Lordship, we have been engaged yesterday.
Can't help it. Let the matter be called up.
Lordship, in that case, could I ask for an accommodation that this matter be taken up in the
It
second
will be
half?
taken up when it is called up. We will see then.
Maybe on in the second half, lordship.
No, first half itself. These things, please, we don't like it. The earlier council should have informed us that he is no longer there in the case. You are appearing for whom?
KK Mahanta, lordship.
No, I know that. For whom? Petitioner or respondent?
Petitioner, lordship.
Mr. Sattar had completed his arguments. What is this practice now? Mr. Sattar had completed his arguments. It is recorded in the order. Your council made a prayer, specific prayer that there is a development which they want to bring to the notice of this court. We allowed it. And today morning, I am told now that no, 14 matter, new council is happened, so adjourn it. We'll have it when the matter is called up.
With regard to item number 29, the petitioner has expired, the matter has become infructuous.
Mr. P.K. Muni, Learned Counsel for the petitioner submits that the petitioner hearing during the pendency of the proceedings had expired, and accordingly, there being none other to press the matter, the issue involved has become infructuous. Accordingly, and there is no other person to press the matter. Accordingly, the matter cannot be taken forward. Full stop. In view of the above prayer, the writ petition stands dismissed for non-prosecution.
Today's daily course list, delivery of order item 1 and 2.
Item 1, 2, 3. I'll pass the orders. I'm making it CAV. You will have it in a week's time. CAV 1, 2, and 3. And 4 and 5 disposed of. Ms. Kejriwal, the matters are disposed of. 4 and 5. 5 also. Matters are disposed of. But orders you will get only next week.
Item 7.
Yes.
Seeing the affidavit, so they said that we thought that they were allowed to revise their bid, my lords. That we thought that
I know that. Now they have clarified that the bid was there. It was a mistake. A corrigendum was issued. Anything further survives. Mr. S. De, Learned Counsel for the petitioner, heard Mr. S. De, Learned Counsel for the petitioner, also heard Mr. P. Kotoki, Learned Counsel appearing for the respondents. A writ petition, writ petition. learned counsel appearing for the respondent number 1, 2, and 3. Mr. Day submits that the present writ petition was so instituted basing on the revelations as made while the letter of acceptance issued to the private respondent number
Five.
5, wherein it was reflected that the bid as submitted by him on 11/11/2022 on consideration was found fit for being awarded the work in question, and accordingly the award was made. Mr. Day submitted that the last date for submission of bids in the matter was fixed on 26/4/2022, and accordingly on account of the said disclosure as made in the said letter of acceptance, comma, the bid of the petitioner having a respondent number 5 having been submitted after the date so fixed for submission of bids, comma, the present proceedings were so initiated. Full stop. Mr. Day submits that the respondents number 1, 2, and 3 have filed an affidavit in the matter wherein it was brought on record that the date 11/11/2022 as reflected in the date in the communique in the letter of acceptance issued to the respondent number 5 on 5/12/2022 was on account of a typographical error, and a corrigendum to that effect was issued on 27/1/2023, wherein it was rectified that the bid of the petitioner hearing was submitted on 26/4/2022. So, Mr. Day submits that in view of the above position, the apprehension as raised by the petitioner in the present proceeding stands addressed, and accordingly he would not like to press the matter any further.
May not record that not press. The lordship may.
Then we'll have to hold that. There are many things we can hold against you here. Okay. In that view of the matter, he prays that the writ petitions be not proceeded further and may be closed. Full stop. Having considered the submissions made by the learned counsel for the parties, and also noticing that admittedly an error had occasion in recording the date of submission of the bid by the respondent number 5 in the letter of acceptance issued to him on 5/12/2022, and the same having been rectified, this court is of the view that there exists no further live issue for adjudication, and accordingly the writ petition stands disposed of. In view of the in view of the order passed so and so, it is closed.
Most of
There are statements in your writ petition which go to reveal that you were in knowledge of this.
no.
And if a private respondent can take up that plea.
Oh, my lord, because we thought that we knew that they submitted on 26/4, but we thought that they were allowed to revise the bid and lower it probably.
Okay, fine. All is well that ends well.
It's been already published, right?
I know that.
Much obliged. The corrigendum was after this honorable court's order.
8 to 10.
Wait, please, your lordship.
Yes, what is this practice being developed?
I'm in a spook now.
No, please.
No, my lord.
This is not accepted. You had completed your arguments.
No, my lord, what happened?
Can you show me that you had not completed your
No, my lord
arguments?
will appreciate, my lord. The litigants has engaged Mr.
Hearing
Mr.
concluded. How can a hearing concluded matter of counsel can be changed?
No, my lord, I'm not.
I
my
had
lord,
not made it CAV. I wanted to dictate the order.
My lord, what my respectful submission is, my lord.
You have wasted the time of the court.
No, my lord, I apologize for this.
We
my lord.
will impose a cost of 50,000 for the purpose.
My lord, this will be lordship, definitely lordship can do whatever your lordship thinks fit.
Can you go
Sir,
open it?
my respectful submission is, lordship will appreciate this, that this lady is illegally evicted from her land, first of all. Second, my lord, that she thinks that if a learned senior counsel appears to let this matter would be heard better than.
Mr. Sattar had argued the matter in length.
My lord,
Thereafter, your colleague submitted that he is filing an affidavit.
this is fine, my
That
lord.
day also, it was not brought to the
My lord,
notice
my
of the
lord.
court that the counsel is being changed.
My lord,
This
We
is
cannot
just
stop-
delay
My
tactics.
lord, no, it's not deleted.
This is delay tactics.
We are not saying that lordship will not.
Yes,
take
Mr.
up-
Borpujari, what do you say?
My lord,
What
we are
should this
praying
court
for-
do?
We are praying for 2 hours, 3 hours time. He will come, he is on a leg in a Supreme Court matter through VC. my lord.
Heard the learned counsel for the parties. The matter was heard and concluded. And hearing was concluded on
My lord, it's shown as part heard, my lord. It's not concluded. My lord.
the order sheet you will have to read.
But it's shown as part heard.
I'm
Otherwise.
sorry.
But we have
And hearing
to-
was
we have
concluded.
to get a additional affidavit.
Hearing was concluded on 6/8/2024, and the matter was directed to be listed on 9/8/2024 for delivery of orders. On 9/8/2024, when this court was about to deliver its order, Mr. P.K. Bhuya, learned counsel for the petitioner, had fervently prayed that a development had occasioned in the meanwhile, which was required to be brought to the notice of this court by way of filing an affidavit. The prayer was accepted and the matter was fixed today. Today, the petitioner prays for a rehearing in the matter.
Exactly not, my lord.
Then why, what is there?
My respectful sir.
You want me to only record the name of Mr. K.K. Monta? I'll do that.
No, no, that's
Then
not that, my lord.
He'll have to argue.
My lord,
We can't spend so much time.
my lord will appreciate.
Full stop. In view of the above position, and which is not appreciated by this court, the above steps taken by the petitioner, no, full stop. Today, when the matter was taken up, it was prayed that the petitioner had engaged a different set of counsels for arguing the matter again, which is not appreciated by this court inasmuch as the hearing was concluded. Full stop. In view of the above position, this matter would not be considered any further as a part-heard item. Registry to list this matter on a date in accordance with its term.
My lord may not take it, otherwise may not.
We don't take it otherwise. We only pass orders. Nothing personal here. Nothing personal here. We have passed the order. You do whatever.
Things, my lord, appreciate just 2 things.
I'm sorry, Mr. Borpujari. All the hard work's gone down the drain.
My lord, what
We'll
my,
be careful in future. Don't worry.
my lord, what my respectful submission?
I don't want to hear it.
My lord,
You have heard my order? That is the end of
My
it.
lord, just appreciate one thing, my lord, just appreciate. I'm not interfering with the order that your lordship. Just
You have got the order.
Just one thing, if I am allowed to say, my lord. It was not concluded because of the fact that lordship has allowed us to brought certain things on record.
That is not only the document which we will look into. We will not go for a rehearing. I have made my notes ready. Everything is ready. He has submitted his.
Just a matter of 2 hours that the senior counsel is on leg, my lord.
It's not a matter of 2 hours, mister. It's a question of rehearing, which we cannot afford.
No, my lord, no, my lord.
I'm sorry. I may sound harsh, but it's pained me.
But I apologize, my lord. My apology.
Your apologies are accepted. That is why I have not proceeded with cost. I have kept it at
My lord,
that.
how can I stop my clients from engaging a senior counsel?
She will suffer. It is her headache. Any interim order operating here?
No, nothing.
Nothing.
We are not in
Then
position.
fine. You enjoy.
Item 11.
And next time, if there is any matter argued before me, wherein there is a scope of further engagement, further hearing, kindly indicate. I'll wait
My lord,
till the
this is
time.
not- This
the
is not
matter-
always, my lord. This is not always. This is a case, my lord, which needs to place before your lordship with the integrity of landlords, my lord. These are all critical things.
It was argued. And we had come to a conclusion also, which may have gone against you, which had gone against you. Can't help it. It is there. It's a part and parcel of our life. Okay, fine, no problem. And take it from me, no hard feelings. Whatever I have to say, I have said. That's the end of the matter. Proceed. Yes. Has the money been paid?
Without interest, they have to.
How can you?
Amount they have released.
How can you?
My lord, only money paid by interest but not paid.
Why?
But
Order is with
Yes, my lord,
interest.
yes, but
Why?
as per-
When are you paying him? Interest. When are you paying him?
Yes, filed a IA, my lord.
For what?
Regarding the clarification of date, but from which date interest will be calculated, my lord. IA not been listed, my lord, today.
You have filed an IA?
Yeah, Lordship.
Okay, we'll clarify. Where is it?
Seeking clarification. No, Lordship,
IA, sir.
it was not numbered, Lordship.
Mr. A.D. Chaudhary, Learned Counsel for the petitioner, submits that he has filed an affidavit, an interlocutory application seeking clarification of the order dated 27/6/2024 to the extent the date from which the interest directed would be so applicable. There is a typographical error here. Sorry, it missed my notice. So, raised it to list this matter along with the said IA.
A serial number, Lordship, 9209.
Said IA stated to have been filed in the matter on when?
On Monday, Lordship. No, I hate to that. On
On
Monday.
21/8/2024.
My lord,
21.
21/8.
September, first week. But can you take from September first week?
First week.
I'll be out of session.
Okay. On 2/9/2024.
Obligation.
12 and 13.
Yes, Mr. Sharma, what happened? Nobody from the petitioner.
In one matter, I'm appearing as a respondent, and one as the appellant. This
Nobody.
Mr. K. N. Chaudhary would be otherwise appearing in that side.
Maybe they have filed an affidavit also.
Yes, regarding that issue of
Issue that has been now
That is
resolved. We
settled,
can
that
go
is
on
settled.
merits.
Kindly pass over the matter for time.
Today will not be possible. You have it on some other day.
next week, Lordship.
As prayed for by the Learned Counsel for the parties, raised it to list this matters again on the week commencing from 27/8/2020.
Oblige, Your Lordship.
Item 15.
Adjournment.
Yeah, please, Your Lordship. But you kindly pass over this matter for timing. Sooner is it like? Quickly over.
16.
None appears for the petition on call. It is seen on the last date of listing also. There was no representation on behalf of the petitioner. Ms. U. Das, learned additional senior government advocate, is present on behalf of the state respondents. In view of the above, the petition stands dismissed for non-prosecution. Who is appearing for the respondents? You are appearing? This matter is pending from 2016, no affidavit. So we will accept the prayer of the petitioner and we are allowing the repetition.
Parawise comment.
So that you keep it to yourself. It has not come on record. We'll not accept it.
May I pray 1 week time?
No,
Next.
Not even a single day. 2016. This matter is pending. 22, you had taken time. Thereafter, the matter did not even reach. Yes, what is your matter?
79. Malad, inquiry report is to be submitted by the BTC, Malad.
Nothing is here.
Is to file affidavit.
Nothing is here.
Malad, so the superintendent.
State government to obtain instruction. So and so he has not received instruction. Interim order to pass earlier to continue. So there is an order of no demolition. We will confirm that. Assam Town and Country Planning Act, the option 1950. And you have the act, copy of the act with you?
I have also adjournment.
On the prayer of the Learned Counsel for the petitioner, not objected to by the Learned Counsel for the respondents, raised it to list this matters after 6 weeks on a date, 2 weeks, 4 weeks on a date, 2 weeks. I'm allowing your writ petition. You don't want to take an order.
My name is not.
Okay, go wherever you.
18.
It's not as per your convenience. List this matter 4 weeks, Petitioner. 13/9/2020.
Interim may be continued.
We don't know. You argue on the interim pay. You argue on the interim prayer. If you are not there in the case, why are you appearing?
Sorry, Lordship, my senior is,
Huh?
my senior, I allocate the surgery, Lordship.
He underwent a surgery.
Surgery.
List the matter after, list the matter on 28/8/2024. Interim order passed earlier to continue until further orders. You
Obliged,
should have told me that before.
obliged, sorry.
It is infructuous.
Lordship, the matter has been rendered infructuous.
Miss
P. Agarwala.
P. Agarwala, Learned Counsel for the petitioner, submits that the issue involved in the present proceedings on account during the pendency of the proceedings has been rendered infructuous. Also, the said prayer is not objected to by Mr. A. Ganguly, Learned Counsel appearing for the respondent bank, respondent Punjab National Bank. In view of the above, the writ petition stands dismissed as having become infructuous.
24.
Your Lordship directed last occasion whether that records have been seized by the authority or not, my lord. This is the instruction, my lord. We have filed our affidavit also, my lord.
File your petition. When?
My lord, on 12th, my lord, 12th of,
You have a copy?
my lord, I have copy, my lord. Copy to.
Oh, the whole thing has come to a
My lord,
standstill.
because of post-factor
Okay.
approval, my lord.
Who is appearing? Can you get any standing counsel of the?
My lord.
No. You are only political vigilance cell.
Party here, my lord.
Then you get that in thing what has happened. You get that instruction. Why that sanction has not been
Has not
granted.
been accorded,
That's it.
Lordship,
Then we will proceed.
my lord.
None appears for the petition on call. Ms. U. Das, Learned Counsel for the state respondent, Learned Additional Senior Government Advocate appearing for the state respondent, submit that the investigation in the matter is not being proceeded further on account of the fact that the requisite approval required under the provisions of Section 17A of the Prevention of Corruption Act has not been yet received from the Government of Assam, Secretary to the Government of Assam, Political Bracketed Vigilance Cell Department, Cell Department. Also, Ms. U. Das submits that she would receive the instructions in the matter and place the same before this court on the next date of listing. Registered to list this matters again on 5/9/2024.
Fine.
25.
Yes, Mr.
At
Nath.
last, my lord, I have realized and I have found I am on a dangerous wicket.
Yes, what do you want me to do today?
My lord, yes. My lord, please come to, my lord, one thing I just want to know. This proceeding is the normal development proceeding. Or it's what, my lord? If she can answer this, my lord.
This is like the legislature's asking this speaker a question. The speaker does not answer. He refers it to
No,
the
it's a bio.
bench. Yes.
This is not important. I want to know, my lord. Is it following Rule 14 CCS rules? Or what, my lord?
You're right. They have proceeded under the Act, Court of Inquiry. But Court of Inquiry, once the conclusion comes, is it not required to be converted into a proceeding? Interesting.
This is not fine because if you, they proceed.
It's
under
not converted into a procedure.
14,
Not
thereby-
14, they ought to issue a,
CCS rules, I mean, if they follow CCS rules,
they don't follow the CCS
no,
rules.
in that, then what, my lord? Then what rules? That's what I got
Penalty has
stuck
been imposed under CCS rules, no?
Hmm?
That's a SSB rules.
SSB rule is clear, Lordship.
Clear. That
SSB
is true.
clear.
up. Now let us see,
Page 36.
page 36.
I have quoted those.
Yes. My lord, please come to second last para, page 36.
Hmm. Hmm. Dismissed as per provisions of 11(2). Read with Rule 26 of the SSB
Yes,
rules on ground of unsuitability.
yes. Now what is
Mr. Nutt, this will require some consideration.
Yes,
We'll
now
have to
please
go-
come to page 22. So
22.
that's is passing through my mind, my lord, whether I may be
No,
wrong.
no. Okay, got it. Got it. We'll hear it.
Got it, lordship has got it.
He has it missed I missed it.
Lordship, this.
Maybe I went too much into the issue. I missed the technicality. You have drawn up the proceedings under the CCS rules and the penalty under the SSB rules. Kindly, maybe you have a
Not
reason for,
procedures. Procedure not followed, if it is the CCS rules, not at all, absolute go by given to them.
but just have your instructions on that. We'll have it. I'll not be here for 2
My
weeks.
lord, really late because
But we'll have it in the first week.
no issue, no issue.
Heard the learned counsels at length. Mr. M. Nutt, learned senior counsel appearing for the petitioner, has raised an issue with regard to the manner and the rules under which, manner in which the proceeding against the petitioner was so instituted and concluded. Full stop. The show cause notice in respect of the petitioner hearing admittedly was issued under the provisions of the CCS rules. CCA rules. However, it is seen that the penalty was so
No,
imposed.
not only CCS rules, read with SSB rules 11.
Okay, it will
Page
like
22.
it will like
Page 22.
it will like it. Full stop. The matter would require a further consideration. Accordingly, registry to list these matters again on when 5th will be fine. 5/9/2024 for further hearing.
Bye.
It will apni move did fine.
Fifth or fifth, there is another part of matter is there.
Whenever you want it.
Any other day, no issue. There are
10th,
cases.
10th, 10th. 10/9/2024. Now I'll have to read.
My lord. Now, I also got interest. I was trying to find out, my lord.
Now I
It's
know.
technical.
That this thing,
Yes.
I missed it.
Yes, my lord.
Okay.
Obliged, my lord.
Yes, what is this?
My lord, page number 44 is that, my lord. That is earlier 2016 guideline, that is the 2016 guideline is under review, my lord. That is why now they are following 2011 guideline.
So it is again 500 meters.
As against, yes, as per 2011's guideline, that is within the 100 meters.
100 meters.
Yes.
He says it is 10 meters. 10 meters is as per the review guidelines,
Review
which is
guidelines.
under
Yes,
guideline.
my lord. That is the main.
What does the state have to say on this? You should have they filed an affidavit? State government?
State government did not collect.
This is not a land under the army cantonment or something. This is government land. It's under the revenue department. Yes, madam, you have to file an affidavit here.
Sure.
Or you receive your instructions. He says his house is beyond the area wherein a restriction because of these army areas can be imposed. According to him, it is 10 meters.
My lord,
And his house is beyond 10 meters.
my lord.
Ms. Gayan says that it should be within, it is within, the range is 100 meters.
Correct.
So if it is 100 meters, his house comes in.
Not sure.
So his house is situated in your land, in a land
Government.
under your control. So deputy commissioner, circle officer, whoever is jurisdictional thing, has to clarify.
Lordship.
Yes,
Lordship,
madam.
oh, maybe.
You have an interim direction?
My lord?
You have an interim direction here?
No, my lord.
They have not taken any adverse measure?
My lord, since my lord, 2000, my lord, is 20.
You are not able to construct.
Oh, yes, yes, unable to construct, my lord. I just started my construction.
Who stopped this construction?
My lord, this, my lord, communication, they have issued that thereby, my lord, my constitution was Annexa 1, my lord. Page 14, my lord. It is, my lord, SDO, subdivisional officer, my lord.
Civil, huh?
Yes, ma'am.
So what do you say? They have, if the government has deemed it that this is the procedure,
My
you
lord,
can't do it. Sorry, I missed on this. You can't do it.
My lord, my humble prayer is there. The government has already, the central government has filed their, my lord, affidavit, my lord. In their affidavit, they are taking the stand that the subsequent guidelines, it is under review. The honorable court directed them to produce their instruction, my lord. Whether the review has come to the finality.
Yes, madam, why this review is taking so long?
Since 2019, my lord.
Application, yes, my lord, that is. I have. Contacted them, my lord, how long that, matlab, they will come to the final, well, that will take some time, my lord. I may be allowed to take further instruction on that, my lord.
My lord, one thing may be noted, my lord. In the last occasion also, my learned friend told that she has received the instruction and she wants to go through it. Whether actually she has received the instruction or not. Because
Yes,
This
5/2/2024.
Yes, madam.
5/2/2024.
5 to.
2024 order.
Order to. এটা কিনা দিছিলে ৰবা। এইটোৱে হ'ব।
Okay.
Yes, my lord.
You have received that instruction. Review completed.
Yes.
Review completed.
My lord, review. Well, I forget.
Okay, after.
Apply, sir.
Just that if you can show that the range is 100 kilometers,
Yes.
we will not come in his aid.
Yes, my lord.
But if it is 10 meters as he has said,
Yes.
then why are you troubling him?
Yes, ma'am.
Just get that, or you have a telephonic call,
Yes, ma'am.
get that instruction,
ma'am.
we'll have it at 2.
Yes, ma'am.
Let's. Petitioner started a bonded warehouse in 1998, my lord.
Lordship, a similar case is being kept as a CAV, Lordship, at Court 20. Just recently, the arguments were
was-
concluded, Lordship. And otherwise also, Lordship, our affidavit has been prepared. We will submit it in 2 weeks, sir.
Did I ask you for your affidavit?
If
4
Lordship
years
allows.
you have not been filing. So what is the beauty in filing it now? The AG has, the CAG has filed an affidavit.
Yes, we would also like to.
Mr. Saiwala, just for my understanding, this property was insured.
Yes,
You have got the insurance amount.
my lord.
You have got the insurance amount. Not paid the insurance. You have made a claim for that.
That I,
Whether that cost of that liquor there is also inclusive of the
house was in.
stock will also be.
Uh,
Whether that insurance of
Stock, I don't know.
stock
Okay.
would also include,
I don't.
say a bottle without tax is 10 rupees,
But
with
only-
tax is 12
Only
rupees.
here, my lord, the point involved here is that duty which we paid when the liquor is removed from the warehouse. for
It has
sale.
not been removed.
Well, that has been burned and destroyed totally, and the Supreme Court taxes has allowed to dispose of that property under the supervision of the
But
Excise
that
Act.
has not been appreciated in that manner by the AG.
So this is the main question here, my lord. On what basis, my lord, they can impose duty, my lord?
Yes. What do you have to say on that?
Lordship, since it is a bonded warehouse, Lordship, right from the beginning, the bond is also annexed in this petition, Lordship. As per that bond, Lordship, whatever liquor is kept in the warehouse, that has already been subjected to duty, Lordship. And the payment can be delayed later once it is issued from the bonded warehouse, Lordship. but the liability remains. And Lordship, there is a provision in the bonded warehouse rules where it says that the commissioner needs to arrive at a satisfaction that the liquor was destroyed due to reasons beyond control, Lordship.
This is what is more, this is risen beyond control.
But that satisfaction has not been arrived by the commissioner of
That
excise.
you have not examined the matter maybe.
One-
Here the
one
whole
thing-
thing has been destroyed.
Okay.
I don't find anything even in the CH's, that is the only affidavit that we have. Therein they have nothing alleged anything against him. If the materials is destroyed, whether still that will be subject to duty. It has not gone out of the bond house.
So two keys are there, my lord. One remains to the department, one needs to us. Whenever, my lord, sale takes place, both the authority must come. And we have to deposit the duty first, then only we can remove it.
Lordship, we would like to submit an affidavit, Lordship, because it was not listed for a long time.
Long time. It was listed in June.
Yes. After that, we have prepared an affidavit.
Before that in May. Before that, it was not listed. Heard Mr. G. N. Saiwala, Learned Counsel for the petitioner, assisted by Ms. G. Duggar. G. Duggar. I'm sorry, sometimes when I'm inside, I forgot the names. G. Duggar, Learned Counsel, appearing for the petitioner. Also heard Mr. I. Botaku, Learned Standing Counsel, Excise Department. Mr. Botaku submits that an affidavit on behalf of the respondents represented by him would be filed in the matter within
2 weeks, Lord.
within 2 weeks. Also, he prays that the matter be taken up thereafter on a date to be so fixed. Also, as agreed to by the parties, registry to list these matters again on 11/9/2024. 11/9/2024.
Seventh is Saturday, my lord.
11/9. 11/9.
Oh my.
Mr. R. K. Talukdar, Learned Counsel, appears for the respond number 5.
From BTC, R.K. Musari was appearing, my lord.
None is there. There is already an order in the same matter. Claim is 9 lakh something. 971, 842. No money has been paid to him till date. You are paying for? Who will have to pay this money? Water Resources. Or you, Mr. Rabha, BTC. Who will have to pay this amount?
Check, my lord, I am not familiar with this matter.
Okay. Who is for the petitioner? Check up. Petitioner Bodloe A. Das. Just check up whether they will dispose it of. No point in keeping it pending because there is already an order.
30.
Yes, Mr. Padok.
In these matters, a report from the chief electrical inspector is necessary. So
That was directed to be produced way back on 27/6/2024. Where is the report?
Unfortunately, we haven't got the report. Lots of
Why?
Can it be next week? I will file it by then.
This was,
Yes,
this
yes, I
order
remember.
is there for last
I
2 days.
I remember it was, I only appeared on the last occasion, at least my humble.
No, you
self.
did not appear, Ms. Das appeared. You does.
You done.
We want the report. We'll finish it off. Why keep this man hanging?
We
Where is
take-
the report? Have you written to the chief electric inspector to submit that report?
Somehow, my lord, it's my lord. And maybe granted.
26. 2 o'clock.
My lord, he will. Fine.
2 o'clock.
My lord,
Get your chief.
16 it's, my lord.
This accident is of when?
September 2020, lordship.
4 years.
I'll try to get it by 2
2
o'clock,
o'clock.
or 16, my lord, on 16, otherwise.
16, tomorrow. Day after tomorrow. 16. As prayed for by Ms. Yudas, list this matter again on 16/8/2024 at 2 p.m. You have not written a letter to them.
Somehow, I am not finding here now.
21 good idea. 21.
Deeply obvious.
Let the report come.
Deeply obvious.
21, lordship.
21.
Obliged.
Item 31.
Lordship, Mr. Majumdar is on lecture for one. Lordship may pass over this matter for time.
We have heard Mr. R. Majumdar. Yes, Mr. What is that? Did you get something?
Oh.
Rahul Roy and those series of cases.
Those are, lordship, here it is a case, apparently a proceeding has been drawn for a misconduct. Now, misconduct, lordship, has to be given a wide meaning. It cannot be something.
This court has already held, and I had to follow that. I followed it, that if it is a misconduct pre of an incident prior to his enrollment, that will be covered not by the CRPF rules, but by the CCS rules.
I'll just try to explain that, lordship. That one.
Sound too clearly, Anand.
Lordship, am I audible?
Mm.
The Supreme Court order which says that it has to be under the CCS.
That is followed by division bench, single bench of our court also.
I get your lordship. But what has to be construed here is, lordship. Lordship will see a person files an application for getting employment. And what does the authority do? Authority sends it back for verification. Had it been something like once documents are given, he is selected. no
Unfortunately,
verification.
Mr. Chaudhary, same very issue. There was a division bench judgment which was followed by my Lord Justice Ete, wherein a matriculation pass certificate was produced. That was held. Then that was sent for verification. In course of verification, it was found that it is forged, that he did not pass. It came back under 11(1) CRPF rules, right? The proceedings were held and he was dismissed. Not only he, around 5 people were dismissed. This went up on, this was assailed here. This court held misconduct correct, but procedure wrong. Liberty, order set aside, liberty given to proceed under the CCS rules.
In fact, I do not know under what consideration
Same.
CCS.
I don't know, but but I am bound by the coordinate bench orders. There is a division bench order. Matter came to me. I found it a little bit unpalatable. The man is here now with a very serious face. That shows he does not have a matter.
No, I was at court number 1.
I know that you are always in court number 1, but not inside, outside.
Inside,
Oh.
inside my lord. First bench.
Then the matter was argued before me. I had my reservations. Then this decision was placed. And it took me considerable period of time to convince myself to follow that, and I had to follow it.
Lordship has no other.
But one thing I did, I think I did not allow them. I just gave a nominal, for the purpose of the proceeding, they were asked to be in service, but I did not give them any financial benefit, holding that if they exonerate themselves, they'll get it from the date. And if an appeal has gone, I don't.
If exonerated, even then, the authority will decide what benefits I would be entitled.
Okay, that has gone up on appeal.
No.
I am bound by my own order. But if you can show me some material, some judgment somewhere, I'm with you.
There is, Lordship, only one of judgment of the Supreme Court.
So this will go.
That,
I will give you liberty to have this proceeding under CCA rules. And thereafter,
but then the fact remains.
the same order I'll pass, which I passed in that order. Do you have a copy of that order?
Fact remains, Lordship, CRP of personnel now under the CCS.
That has been discussed in the earlier orders.
I know.
That would be, Lordship.
That is judicial discipline I'll have to follow. I'm giving, if you want, I'm open. You can try.
Lordship will take it on Monday and
Okay.
try to.
Not
Because I
Monday.
got some
Not Monday.
judgments not-
We'll have it on 2nd. 2/9. You are here?
Yes.
2/9.
Once the
Only
matter
thing is the order is with you. The delivery is delayed.
1149 of 2013 is the judgment, which Lordship.
Double?
1149 2013.
1149.
5 repetitions at a go was disposed of.
Madam, 1149 2013. Item number 31 of committee.
Probably on the last occasion I have given a copy. I'll provide another one.
No, we'll have it. Don't worry. We'll have it.
What Lordship had held at the end is the interference with the penal, however, materials got on record having disclosed commission of misconduct by the petitioners, they cannot be exonerated from the allegations so leveled against them, and the present proceedings having been interfered by this court on procedural irregularity existing in the proceedings, liberties granted the respondents to initiate appropriate proceedings under the provisions of CCA rules. The interference with the penalty as imposed upon the petitioner would have resulted in issuance of an order for reinstatement of the petitioners in their respective services. Given the nature of the allegations as leveled against them, this court refrains from issuing any direction to the respondents for reinstatement of the petitioners in their respective services. Petitioners, however, would be deemed to be in service for conduct of proceedings as now required to be conducted under the respondents by the under CCS rules. Lordship did not even give a time frame as to when they will conduct it.
That we will rectify this.
Here, my lord, the managing service.
Managing service.
Yes. During service, they just take.
Better positioned.
They just take.
So that my order will not vary.
It will not do the harm intended.
It won't be that advertisement of Amitabh Bachchan, Jor ka Jhatka, erasing.
The intent continues, my lord.
Heard the learned counsel for the parties at length list this matter again on 2/9/2024 for further consideration. The interim order passed earlier to continue till then. You tried to formulate.
Lordship.
I'm not very, because I'm bound by the Supreme Court order. I can't go beyond that.
Discipline, Lordship.
I can't go beyond that. But if you can get me something, because I feel that this issue cannot be termed to be a thing which is prior, because this was detected during service.
This during service,
It-
that was. that is
It
what-
goes to the very conduct of that man. So misconduct is born.
So
But
mis-
Mr.
misconduct-
Majumdar was very successful in getting
misconduct
those.
will start from the date he has submitted that document.
And even on the date when he had enrolled himself, he had given him that document again.
He's in service on the basis of that document.
CCS rule will apply as because for the act itself and the rules. Wherever nothing provided for,
Then it goes
automatically
there.
CCS comes in.
That's
So
true.
CCS will come in at all times. And if they follow CCS, the procedure will be more summary. Obliged.
I'll hear him again.
Wait, Your Lordship. I'm only agreed by
The question posed
That may be.
was wrong.
The only remark, Your Lordship, because it goes to entire Assam, Your Lordship. That is the only remark. It may be expunged, Your Lordship. I'm only paying
The
for that.
question asked of you was wrong, whether an FIR was lodged or not.
Yes, Your Lordship.
You replied, maybe you were within your rights to make that reply. You said FIR lodged, FR filed. But the question that the FIR was lodged after around a month, that was not demonstrated by
It
you.
was not also question to me.
It was not.
I
questioned.
very
Yes,
specific.
That is what we have reflected in our affidavit.
not very. You want only that part of the order to go.
Yes, only that. Nothing. Only that.
Heard Mr. T.S. Dury, Learned Counsel, T. Dury, Learned Counsel for the petitioner. Also heard Mr. S. Borua, Learned Counsel, appearing for the. Nobody appears for respond number 1. Anybody appears for respond number 1? And Mr. Dury, from where I can get to know, what was the investigation directed by this, directed by the commission to the SP to be? Is there anything on record?
Yeah.
Okay. Police accountability from the director of the commission.
Some communication might have been sent. This letter, 2010-2020 SPAC, say page 39.
Yes, sir.
Where can I get this letter? Copy of this? Because then the order would be more. The exact question I can reflect. Page 39.
Yes, Your Lordship. I do not have the order, Your Lordship.
Can you get a copy of that?
I will try.
Friday.
Yes.
Huh? Right? As prayed for by Mr. T. Dury, Learned Counsel appearing for the petitioner, list this matter again on Friday. This is the order that I'll pass.
Yes, sir.
The question posed was this, answer was this. In that view of the matter, the petitioner was not, had contemplated that he was not required to make any further
Exactly.
observation thereon, and accordingly he limited his report to that extent.
Yes, sir.
So it was a bona fide error, and accordingly the same ought not to have led to such a comment which would have an adverse impact in his service career. Accordingly, that we'll quote that comment. To that extent, the comment would be from that order stand expunged.
Exactly.
But you give me that question.
Yes. Friday night, Your Lordship.
Right this way.
Yes, sir.
16th. Let buy slip to you. Human? Yes. Mr. Das, there is already an order. Oh, no, not this, not this. Not this. Sorry. They were supposed to file. Sorry. There was another matter of yours. No, this is the matter only, no?
Lordship, I am appearing for respond number 3, 4, and 5, Lordship. Next time required to file our affidavit, Lordship.
Why?
But we have not received our instruction.
For the last around 3-4 days, this is only the thing which we are doing.
Yes, Lordship.
Is the amount admitted? Only thing is that the reply to the legal notice says that some approval is sought for. That means the work that he has executed, you have admitted.
Lordship, response from union in response number 1 is also required, Lordship. We are only an executing authority.
No, it's for you to get manage the funds.
Yes, Lordship.
It's for you to manage the funds.
Yes.
Why have you asked him to make construction if you don't have the funds?
We need instruction, Lordship. Last chance may be given, Lordship. After date, Lordship.
We will compensate you by way of interest. Don't worry.
Because until and unless my lord affidavit is there, I don't know what is the admitted amount and what is the dispute.
Okay, fine.
Because for the disputed amount, I'll have to go for a suit.
But from the reply, we don't find any dispute per se. Heard Mr. Adas, Learned Counsel for the petitioner. Also heard Madam
R. Deca.
R.
Deca.
Learned Counsel appearing for the respondent number
3, 4, and 5.
3, 4, and 5. Ms. R. Deca. submits that she be given a last chance to bring on record the stand of the respondents number 3, 4, and 5 by way of filing an affidavit. Prayer is not objected to by the learned counsel for the petitioner. Full stop. In view of the above, the respondents number 3, 4, and 5 are given a last chance to file their affidavit in the matter, failing which this court would proceed to decide the issue involved by basing on the materials brought on record already. Full stop. Ms. Decca also shall on the next date receive written instructions in the event the affidavit is not so filed about the amounts due to the petition and admitted by the respondent number 3 in the matter. Full stop. And place the same before this court on the next date of listing. Full stop. Raised it to list this matters again on 6/9/2020. We have given you adequate time. If you don't file the affidavit, that at least that written thing should come on record. Right?
1 and 2 also have to file an affidavit. 1 and 2 has also not filed an affidavit. The main.
Their project, why should we go beyond them?
Deeply.
Yes. Madam, make an inquiry if they are entitled, pay it.
Your coordinate bench order has been furnished to your lordship. WPC 2700/2023.
Where is it?
Lordship may have a look.
Where is it?
Against that, retable was preferred, my lord, and retable admitted, my lord. That is order, my lord, referring, mentioning my friend, my lord. Against it, retable preferred, my lord.
There, your
retable
lordship.
Admitted, my lord.
Show me. Where is it?
WPC 2700
2700
of 2023. Monisha Khatun at Monisha Khatun versus State of Assam and 5 others. This is a judgment and order delivered by Justice K.R. Surana, sir.
Asami, you have a copy?
I have on my phone.
We'll have it after some time. We'll have it after some time. 33, no, 34, 35, 36.
36.
All of it. अपनी खाली आता कॉपी होने दियो कॉपी आता होने दियो
My lord, similar matter has been disposed of, lordship. This is also on same footing. Outstanding dues, my lord.
Have you paid the 10 lakhs?
We have paid.
Paid. So today, we'll consider your prayer, no problem. Today, your dues, with or without that 10 lakhs, stands at around 57,69,161.
No, my lord, that is not correct.
Be that as it may, they have brought that on record. And there is nothing, no material coming on.
They have submitted, it is Vijaya Steel and Wire.
That is that was the possessor. Now it is taken over by Cotonox Printers Limited, India.
It is not yet.
Now
taken
how much is dues according to you?
over. They have charges GST.
Mr. Sharma, according to you, what is the due?
That is when I have to take.
You can have the instruction by 2 o'clock.
2 o'clock it is not.
We will not allow this thing to go on. I have already passed an order.
Malati, so far I filed this is so far Foxton.
Mr. How have you, this dues are there till January 24?
Yes, my lord.
Rent?
Yes, my lord. And what happened, my lord, it is not any dispute because it's a settled position of my lord dues.
What is the monthly rent?
My lord, monthly rent, my lord, this is here, my lord. One is 5,000 only, very nominal amount. And
okay.
long back, my lord, they are defaulted.
Okay. Forget the GST, forget the other part. Minusing those two, what would be the total amount that is working out?
57 lakhs, my lord.
No, excluding GST and
My
other
lord, yes,
taxes.
my lord. That figure will come to my lord this side, my lord, column number 4. That has to be segregated, my lord, because.
Can you just do that for me?
Yes.
We'll ask them to pay that to you. Full amount.
But otherwise, my lord, how that survive, my lord? Because units are, my lord, for the
That's
benefit
why
of
we will ask the petitioner to deposit that amount, thereafter consider his case. Or we will vacate the interim order if he doesn't do so.
Lordship already.
The other part wherein is GST and all, wherein
these
is,
are the separate.
we will see, because that can be compensated by interest.
And Lordship on same footing, my lord, Lordship already passed order, that is 1974, my lord.
I'll follow my
Exactly,
orders.
my lord.
Why are you apprehensive that
Yes, my lord, there is no-
why are you apprehensive? I'll not follow my orders. I'm bound by my orders also. But give me the amount receivable minus all
Right,
those
my lord.
paraphernalia, taxes, this, that, rent.
And Lordship, can you see second aspect that after getting the stay order, my lord, how they are arranging? Earlier they paid certain amount. Now they
Mr.
have to-
Samaria, that is why I'm asking you, why are you reiterating? Get that amount on record
My-
by 2 o'clock.
But,
We'll have it at 2 o'clock.
my lord, minus.
You are interested for money? Come back at 2 o'clock. Or after 2 months. This is public money.
We have to, my lord, we have to calculate the figures.
Just, it is there. Just
Exactly,
work
my
it
lord.
out.
My lord, Lordship, if Lordship desire, my lord, only say, if Lordship pass a direction to the, my lord, minus service tax and my lord. then
No,
that-
I want the amount. We'll have to show Mr. Sharma also. I want the rent amount
Okay, my lord.
that he is bound to pay. We'll ask, because 10 lakhs has already been paid. Reduce that, and what is the balance? Ask your office, give me that amount by 2 o'clock, we'll pass orders. Mr. Sharma, the rent part, you will have to pay up. Otherwise, we'll not consider. And the other part, we will consider. Whether GST is applicable, how applicable, we'll see. But the major chunk,
Rent you will pay.
that he let him have the calculation. 2 o'clock. If you're not there, you can ask your junior to be here. I'll only limit myself to the rent component.
But only rate part, my lord.
Only rent.
My lord, but let me and other thing are the part of agreement, my lord.
We are not
But-
excluding him.
But-
You want money to survive,
Absolutely, my lord.
right? And why is there no revision of the rents?
Revision is there, my lord. That revision, my lord, periodically.
Including revision, you give me the
My-
calculation
my-
at 2 o'clock.
my-
And that would be as per the agreement.
Yes, absolutely, absolutely. We will
Don't
not,
go
my
beyond
lord,
the agreement.
breach of that condition.
You give a copy to the senior counsel also. Let him also go through that.
Right.
And Mr. Sharma, you're not here. You can instruct your junior. He will make the submissions. Duta Bazariko. Yes, what happened? Have you submitted the application?
I've submitted and I've sent my email on 6th August.
Yes. Received?
As per my instruction, they have not received the application, Lordship, neither the email,
Mr.
Able.
A. Borua, learned counsel for the petitioner, submits that the petitioner, in terms of the orders passed by this court on 5/8/2024, had submitted her representation in the matter. Had resubmitted her representation dated 2/5/2024 on 6/8/2024 by mail, as well as sent a copy thereof by way of registered post, registered
post.
post with AD. Also, the tracking report as placed on record reveals that the same has been delivered to the addressee concerned. Also, however, Ms. R. Devi, learned CGC, submits on instructions that the representation of the petitioner has not been received in the office of the respondents. Also, without further considering the rival submissions placed on record, the learned counsel for the petitioner shall furnish a legible copy of the representation so submitted, signed in original by the petitioner to Ms. R. Devi, CGC, or a copy there.
The original has been sent to.
Okay, copy will do.
Copy I have already given her.
yes, Lordship.
Ms. Furnish a copy of the representation dated 2/5/2024, along with the mail, a copy of the forwarding of the same by the mail dated 6/8/2024, and also the postal receipt of the sending of the hard copy to Miss R. Devi within the course of the day. Miss R. Devi shall forward the same to the concerned authorities, and they would now, on receipt of the same, carry out the further processing thereon, facilitating the petitioner to receive her due pension. It's pensionary benefits,
Freedom fighter.
freedom fighter pension benefits. Also, the respondent authorities shall process the matter and issue orders thereon within a period of 15 days from the date of receipt of a copy from Miss R. Devi. Also, CGC. Raised it to list these matters again on
Also, 4 weeks may be granted, also it needs some time to take decision.
1 month, 30 days period. This matter again on 16/9/2024 for further consideration. You give it. Further consideration to Patiya.
That relates to appointment of retail outlet dealership of HPCL. In this case, not respondents were.
No, you satisfy me.
Malas.
Your case is you have brought on record two particulars, two factors. That the circle officer has given a note that maybe that land may not be feasible, but this land is feasible. You have not disputed that that land does not belong to the, what is the respondent here?
Respondent of 5.
Commissioner.
Yes.
That letter is at page.
That is page 51 and 52, Miller. 2 letters. Circle officer's letter is at page 51.
So how is the respondent number 5 in possession of this land? Whether it is the owner or he is a leaseholder?
That is not clear.
Who is appearing for the respondent number 6? You have. How have you come into possession of this land? What is the relation? Landowner?
That is on the issue, my lord. I'll kindly see paragraph 13, my lord. What is the grievance, my lord, the petitioner, my lord? Page 9, my lord. His complaint is that the respondent cannot take the alternate land, my lord.
I only, fine, I got it.
Yes, my lord.
Yes, this is a lease land, long lease. Huh? Do you have anything to demonstrate that?
But we have an addendum, my lord.
No, the clause is there. The clause is provided for at page 20.
22, my lord.
Right? So the alternative land can be given.
Yes, my lord.
I only want to know that whether that comes within, still comes within group 1.
Okay, sir.
Page 50. Page 50. Page 50.
50.
Yes, 50. Page 50, if your lordship sees my name features in serial number 2.
No, this was in relation to your first land.
Yes.
Right? Thereafter, the second land came into being. Now, the second land also, you have a long-term lease?
Yes.
Something to that effect.
Yes, yes.
But we have accepted this alternate land, my lord.
So on the date you had it, whether there was a long-term lease available. That is your case. If they don't have a long-term lease, that is gone because he'll be taken out of group 1. If he's taken out of group 1, then he will not be, that lottery system will not work for his case. When was the lease executed for the second?
I'll produce a record, my lord.
10/20/20.
Huh? But his only grievance, my lord.
10/20/20. 10/2/2020.
10/2/2020.
Yes.
And the NIT is of?
It is of 25/11/2018.
This is second lease.
Advertisement.
Second addendum, your lordship, it was issued for us.
And the second addendum is of?
Second addendum which has been given to
Is a 4/2/2022, my lord.
2022.
4/2/2022. Do you have it?
Yes, my lord, I have provided, my lord.
This one?
Please, that number.
I provided the copies to my current senior friend.
No, this is addendum to LOI.
Yes, my lord, we have accepted this offer, my lord, the alternate land, my lord.
So this alternative land, when it is offered,
Yes, my lord.
need not be there or a lease need not be in existence on the date when the notification for advertisement was issued. It
Yes,
can
my lord.
come
On the-
into
on the
being
last date of
afterwards.
application, my lord.
It can.
Yes, my lord.
Can you just show me?
Yes,
where-
my lord. Now, kindly see, my lord, first, my lord, the page 80, my lord, kindly see land, my lord. Of the guidelines, my lord. He is group 1, my lord. Mayor is, my lord. The applicant having suitable piece of land in the advertised location, either area either by way of ownership, long-term lease for a period of 19 years, 11 months, or advertised by OMC. Then group 2, this is group 2 by agreement for sale or group.
That we are not concerned.
Group 3 who does not have the land, my lord. Then in case, that is his case, my lord, on which the petition is happening, my lord. In case the land offered by all applicant under group 1, group 2 is found not suitable, not meeting the requirements, then this applicant is under group 1 and group 2 along with the applicants under group 3 who don't offer land along with the application would be advised by the OMC to provide suitable land in the advertised location space within a period of 3 months from the date of issuance of the intimation letter to them through SMS/email.
Now show me where you can have this alternative land.
Yes, my lord. Page 22, my lord. Note 3, my lord.
Okay.
There may be a situation where the land offered by the candidate in the application, including land, alternate land offered by the group 3 or group 1, group 2 applicants, miss all specifications as laid down in the advertisement and on the basis of which LOI has been issued or proposed to be issued, and the LOI holder or the selected candidate to whom LOI is proposed to be issued would like to offer alternate land due to whatsoever reason, such as may be considered by the OMC subject to the alternate land meeting all the specification and is within the advertised location of the space. Now, petitioner submission is that
First,
we could
the
not-
first land that he had given,
Yes, my lord.
against that LOI was issued.
Yes, my lord.
But something happened, maybe
Yes,
the
ma'am.
district
Then he-
authorities came in,
Yes, madam. He offer alternate land, my lord.
alternative land, that was also approved by the district authorities, but license, everything was
Yes, ma'am.
given. And then you made an addendum to the
Yes, ma'am.
LOI. And accordingly, you are running the.
Yes, ma'am.
That communication I do not have, that addendum, what is there?
You have it, he'll give you a copy also.
But Lord, if you go by that clause 5, page 18, Lord, what it
That
says,
is there at page 22.
22 I have done. I've gone through, but
It is permissible.
it says that if there is no suitable
The
in one
land, the land that is there, it's not suitable. Then he will move out of L1, group 1. But if the land is suitable, LOI is issued, subsequently something comes up by which he is required to give an alternative land, that is not prevented. And the letters at page 51 and 52 support that.
that aspect is there. That aspect is there, but that addendum, what my learned friend is referred.
He'll give you a copy, don't worry. Addendum is only with regard to the modification in the LOI. That's all. And the LOI is not under challenge here.
That only that I am on that violating these guidelines, it was issued.
Anything more, Mr. Haloy? Anything more? You are paying for?
For 2, 3, and 4, ma'am.
And Lord, what I would like to submit, if that addendum, you can bring it on record.
Give him a copy.
I will get a chance to go through that.
Hello.
Give him. We'll have it at 2. You give him that copy. We'll have it at 2.
On Saturday because
No.
take
Today
instruction
itself.
from my client
Nothing
also,
is
but
there.
On Friday.
We have applied our mind.
On
2 o'clock.
Friday, Lord, I will take
2
instruction
o'clock.
from my
You
client
see,
also.
2 o'clock. You just a phone call away.
41.
Have you got a house subsequently?
No, my lord.
May I please, your lordship? Lordship, I'm appearing on behalf of Mr. S. Datta for PNRD. In this matter, we have received our instructions. We are preparing the affidavit. We'll file it in 2 weeks.
Several times they took money.
Miss
P. Biswas.
P. Bishwas, Learned Counsel, appearing on behalf of Mr. S. Dr. Learned Standing Counsel, PNRD, submits that the instructions have been received in the matter and an affidavit on behalf of the said respondents would be filed on or before 28/8/2024. Full stop. Registry to list this matter again. Full stop. Accordingly, the matter stands adjourned. The respondents are to file their affidavit in the matter on or before 28/8/2024. Registry to list this matters again on 2/9/2024 for further 2/9/2024. Full stop. Subpara. In the event the affidavits are not so filed, this court would proceed to consider the issue arising in the proceedings, in the present proceedings, basing on the materials already available on record.
42.
Yes, Mr. Chaudhary.
Lord, I'll pray for a fixing an early date for disposal of this matter.
Fine. When? You give me.
Lord,
Tuesday next,
subject to-
Lordship.
Subject, not Tuesday, Lord, put it be on 28 or 30. Or if your Lordship wants to have it a hearing there, 3rd or 5th. Is that convenient to Lordship?
No, the 27th is a Tuesday.
Let us come after vacation, Lordship. After the
Vacation?
puja
1 second.
Vacation.
After the puja vacation, because they are, we want it as soon as possible. Next week, maybe, Lordship.
22nd, Mr.
22nd.
22nd.
My Lord,
22nd.
Put it on 27.
27.
Seven.
Fine. Mr. Swaikya, any problem?
27.
Sorry, 28.
28.
27, my Lord, I'm tied up.
28 is a
29.
Wednesday,
28. 27.
28 and 20, yes, at 2 o'clock.
2 o'clock.
Ah.
Yes.
As prayed for by the heard Mr. K. Chaudhary, Learned Senior Counsel, assisted by Miss So-and-so, P. Mounto. P. Mounto. Madam,
I Kakur.
okay. Learned Counsel appearing for the petitioner, also heard Mr. D. Saikia, Learned Advocate General Assam, assisted by Mr. S. Bora, appearing for the GMD authorities. Full stop. As agreed to by the Learned Counsel for the parties, registry to list this matters again on 28/8/2024 for a final consideration.
Deep.
Could it be at 2 p.m.? Could it be referred?
I'll not be there, so it
Lots.
will not be proper.
We'll make a mention on that.
If I was there, I would have fixed it at 2. No problem.
Lots.
None appears for the petitioner on call. Registry to list this matters after 4 weeks on a date to be so fixed by it.
Correspondent 1.
I am appearing for respondent number 4.
Miss N. Baudelaire, Learned Counsel, Standing Counsel Revenue appears for respondents number 1. And Madam, you,
2, 3, and 4, my Lord.
your name,
And Barman on behalf of Dinath.
Miss N. Burma appears on behalf of respondent number 2, 3, and 4.
My Lord, short date may be given, my Lord.
Registry to list this matters again on
Next week, my Lord.
27/8.
44.
In this matter, kindly allow us some more time to file a rejoinder affidavit, Your Lord.
On the prayer made on behalf of made by Mr. S. Day, Learned Counsel for the petitioner, who submits that further weeks time may be granted, 2 weeks time may be granted to 2 weeks.
6 weeks, because these persons are in Karimganj, Your Lordship. So
Karimganj, no floods.
No, we have already communicated. They need
No
to-
floods. What is preventing them from coming?
Yeah.
Earlier, the better for you also.
4 weeks at least.
4 weeks time to bring on record the rejoinder on behalf of the petitioners. So, as a last chance, matter stands adjourned by 4 weeks, enabling the petitioners to file their rejoinder in the matter. Registry to list those matters again on 18/9/2024.
Yeah.
So, any interim order?
No.
Mr. N. Goswami and Ms. M.S. N. Bodole appears for their respective respondents.
Matter pertains to non-payment of contractual dues. The work is otherwise been admitted by the executive engineer. The authorities can verify, and then if found all right, they can make the payment. The amount.
What
is
do you
very
say?
small, like.
Lordship, as per my instruction, your lordship, it's matter, the scheme relates to flood, FMP flood management program scheme, your lordship. Here 90% share is the central government, your lordship, Ministry of Jal
Who has
Shakti.
awarded the work? Central government.
No, your
Then
lordship.
you are to make the payment.
No, we are the executing authority.
Be that as it may, who has issued the tender? You have issued the tender.
Yes, your lordship.
Then
Lordship,
in the tender, was it mentioned that the money will be paid by the central government, not
in
by
the
us?
contract agreement, it is mentioned,
Where?
your lordship.
Where? Show me.
Contract agreement is not annexed here, your lordship.
Show me.
We have, from time to time, we have placed a demand before the Ministry of Jal Shakti is implemented here, your lordship. By the
Last occasion, the concerned department of the central government was implemented, your lord.
Ministry
Who is
implemented,
appearing?
your lordship.
Ministry of Jal Shakti. Who is appearing?
Looking to implementation. Lordship, we have recently also placed the demand on
It's been
28
accepted notice last time.
2024.
Madam, you have accepted notice.
Yes, madam.
Miss A. Gayan, Miss. They can learn it. Standing counsel. You admit to this. Do you admit to that the dues?
Yes, your lordship.
You have admitted.
We
You have instructions.
Part also.
You have instructions.
Yes.
Madam, this is a very categorical statement. I'll record it. Then you can go beyond. If you admit to his dues, we will say that central government ask her to take instructions.
Lordship, my instruction is only that we have placed the demand before the Bahuputra board for forward submission on to the Jal Shakti, your lordship. And we have lastly paid on 28/2/2024. Recently also we have also placed.
Show me your instructions.
That out of that total amount that was to be paid, the state share has already been paid, your lord.
State share paid.
Yes.
140,950.
The total value of the work was 3,25,000.
So 140,950 is the pending,
Now that
which is the central share.
Yes. That is what the state has said.
What is para 3?
I'm sorry, your lord, I'm placed on wrong instruction, your lord. This is the correct one, your lord. Sorry, your lord.
Similar kinds of matters are fixed on 28 August for my instruction on behalf of Union of India, madam.
Similar matters.
All are regarding the release of funds from the central government, madam.
Four admitted. Four admitted. Four in para 4, you have said that the work is complete. This is the measurement. So balance is this, that they say it's admitted. Ms. Theka, learned counsel appearing for the Standing Council Water Resources Department submits that in terms of the instructions received by her, the claim of the petitioner to an amount of rupees 1,40,950 is admitted by the department. However, the said amount is now to be released by the Ministry of Jal Shakti, that is the respondent number 7 hearing, and according a demand in this connection has already been forwarded to the said ministry through the Brahmaputra board. Also, however, the amount as would be required to be placed at the disposal of the state water resources department has not yet been placed by the central government. So in that view of the matter, the views of the petitioner could not be released. Ms. A. Gayan submits that she would receive her instructions in the matter and place the same before this court on the next date of listing. Registry to list this matters again on 28/8/2024.
Item number 57 also, Your Lordship, same
Same.
similar work orders, same department.
Same.
57.
57 is same. Respondents also same.
Respondents also same. Jal Shakti has been included as a party.
Same. 57 to allow. 28 or declare. Same order, 58 or to my 57 or to my.
In this case, Lordship, we have not listened instruction law. In this case, I need some time, Lord.
This is the second petition prepared by the petitioner, my lord. Rights of the petitioner has already been established.
24. We'll give them one more chance. On the prayer of Mr. N. Goswami, registry to list this matter, who submits that the instructions in the matter are awaited.
My lord, may
So-
kindly fix it here.
Registry to list this matters again after 3 weeks. In the meantime, invariably, the state respondent shall bring on record their stand by way of filing an affidavit. Registry to list this matters again on 16/9/2020. Ms.
Very much.
N. Bordeloy, Learned Standing Council, Revenue is present.
Your Lordship.
5 minutes. Can I just take a break for 5 minutes?
No.
We'll come back in 5 minutes. Yes. What is the development?
Lordship, I have instruction relating to on the last queries, Lordship.
Hmm.
Lordship.
Hmm.
As per clause 30.2 of the bid document.
Hmm.
Lordship, may I read or have to submit the documents, Lordship?
One thing. This will take some time. This will take some time. Mr. Das, this will take some time.
It will take some time.
But thing is that they are also very occupied. I am not here tomorrow. Day after tomorrow is my last day. I'll not be here for 2 weeks.
Yes.
So if I hear it, you will all have to wait for 2 weeks to further date. So this is
think
an
it will
urgent
be-
matter, tender matter. This has to be The work
Urgency is there.
urgency is
There
there.
is a stay order operating.
There is a stay order.
Your Lordship,
So we'll
Mr.
have it
Das-
on next Tuesday. We'll have it on Tuesday. You can have the arguments made before a bench, which is there. Tuesday.
Your Lordship, may I pray some other date? In fact, Mr. Das cannot make any submission in this case.
Which Mr. Das?
The Sir H.K. Das, my learned senior learned friend who is appearing for respondent number 5, he has no role to play in this case. He cannot make any submission because it is between me and the department.
Just so.
Milord, what is this submission?
Mr. Das, he has not made that submission to you. He has made that submission to me. Let me deal with it.
Yes.
Yes, Mr. Sinha, what is your argument?
Your Lordship,
That
what I-
respondent number,
5, he's saying that it will take some time.
why have you made him a party?
Exactly, Your Lordship.
No, why have you made him a party?
I'm saying, Your Lordship.
Please, Mr. Sinha, this court has said that the matter will be fixed. You are having a stay order.
Yes, Your Lordship.
This matter would be fixed on 21st for hearing. It's a Tuesday. We are fixing it on 21st. Right?
20th, I think, Your Lordship.
21st.
Wednesday.
Tuesday. Oh, sorry. 20th.
20th Lordship
20th.
is Tuesday.
Tuesday.
Tuesday,
So Tuesday,
I might have some difficulty. Can it be on 21st or 22nd, Your Lordship?
we'll have it on 19th. As agreed to by the Learned Council for the parties. Miss
Take it on 19th Lordship.
19th only.
19th.
No. Ms. P. Kotoki, Learned Council for the appearing for the state respondents has submitted that the instructions as requisite has been received by her in the matter. So, the Learned Council appearing for the petitioner as well as the private respondents have expressed an urgency in the matter, and accordingly registry to list this matters again on 19/8/2024 for final consideration for 19/9. So an endeavor would be made to dispose of the said of the 19/8, 2000.
That line may be included, Milord, the endeavor shall.
An
be made,
endeavor would be
because
made to
there is a
dispose of the matter on the next date of listing.
Yes. Highly.
Highly obliged.
Your Lordship, the interim order.
Mr. Sinha, everybody has their own urgency. You have invited them in.
Your
So they
Lordship,
can always make that submission.
Your Lordship, I can say one submission on the basis of the record. I am challenging the technical bit. It is between me and the department.
Why have you made him a party then?
Because, Your Lordship.
Why have you made
as
him a party?
No. Your Lordship, the Honorable Supreme Court has categorically stated. I am not saying so.
Go. That's why, because the
When the
Supreme Court
technical
said
bit is
that
rejected, Your Lordship will kindly.
everybody has to be brought a party.
No,
Why?
No, Your Lordship will kindly listen to my submission. It is between me and the authority. The department is the authority. The department will decide.
Okay, at 2 o'clock today.
Fine.
We'll have it at 2. We'll hear it.
No, my submission is only limited to the.
We'll
extent
have
that
it at 2, Mr.
He
Sinha.
cannot say that why my bid is not.
That's
to
what
be
I
accepted.
said. Between you and you, both of you, if I find that you have a case, we'll allow it. If not, we'll dismiss it.
Yes, Your Lordship.
It's not done like that, Mr. Sinha. Don't get excited. Don't get excited unnecessarily. He's a respondent here. He can make his submissions. It's for me to consider both. Right?
My
And
sub-
pass an order balancing both of your rights.
My submission is.
And I
only
have
to the
fixed it
extent
on
that-
20th. What is the harm in that?
Nothing, Your Lordship.
Then why make this unnecessary things?
Your Lordship,
un-
my submission is only to the extent that he cannot say that why my bid is to be rejected.
Who?
That is my specific case. On last occasion, when he was making a
He
submission.
will be in a position to say that because your bid is rejected, his line is more clear. So he'll be, as a prudent businessman, he will also make those submissions.
Therefore, Your Lordship.
If you are decide that you would be the first one to make that submission,
No, to that extent, I'll place the.
Then-
judgment in that.
that is for you to do it. But why are you restricting him? Let him make whatever submission he want. You stand not on his submissions. You stand on your case,
Exactly.
on this foundation of your case, not on his case or what he will submit. Right? Don't forget that.
No, what he submits is nothing, but he cannot say why my bid is. to be
Oh,
rejected.
Mr. Sinha, that is for me to decide.
Yes, that's
You
what-
have to say what you have to say. What Mr. Das or Mr. Kotoki says, it's for them to stay. Neither they can build up your case nor destroy your case. Your case will stand or fall by your own standing. They can only point out, which you can't stop.
to that extent.
You are decide also nobody can stop. I will not permit that in my court. Everybody will have an equal opportunity of hearing. What is required, that I will take. 20th.
Deeply.
Obliged.
Highly.
19.
19 years. The lordship interim order passed earlier.
Interim order passed earlier to continue till the next date of this. It is done up,
51. You will be expected to appear on behalf of Respondent 8, my lord.
What do you say, Mr.?
Yes, yes, similar order to be passed in other cases. I am not opposing to that.
Give me a copy. Similar order.
Yes. It will go to the district judge now. They have to approach that.
But here no money has been paid, I suppose. No money has been paid.
No, my lord.
No,
This is,
as of now, no.
Sorry, my lord, and line is above. Nothing has.
I think I have also passed some orders.
Yes, maybe, my lord. I don't know. Oh,
How many petitioners?
2 petitioners.
Two petitioners. Both of them have not been paid even
Yes.
a
Yes,
single rupee.
yes. As
Huh?
of now, no.
No money. This was not done. It would be learned district judge, which court?
Baksa, my lord.
Baksa, same.
Baksa at Masol.
Mr. Saibala, you will be appearing for the newly.
Number 8, my lord, newly included.
And who will be? अपनी लिखी लो उसमें कौन की appear करें. I will pass a similar order. A similar order. ये वाला. खाली वो later कौन है देख लेना. Dispose of.
Lordship, I am preparing for
It will also
response EF5.
Just
Lord, it will also 30 days. Within a month.
same thing,
Obliged.
same conditions. 30 days from today, same condition.
T2.
Stop order is of 22.
10, 21.
And Jitumuni does 17/8/21. Indranil Sharma 22/6. Rumi Kolita 18/8. So all are before the stop order. So we'll direct that moment this order is withdrawn, they will consider your case in terms of the Excise Act and rules. Heard Mr. N.J. Katunia, Learned Counsel for the petitioner. Also heard Mr. N. Goswami, Learned Counsel appearing for
All
the
respondent.
respondents number.
All.
For nowadays, excise is not, they don't have a standing, you are standing counsel. Okay. Standing counsel and excise department appearing for the respondent, all the respondents. Also, the petitioner hearing as a petitioner by way of instituting the present proceeding has raised a grievance with regard to the action on the part of the respondent authorities in not issuing to him an IMFL on license even after the application of the petitioner for the purpose was found to be eligible for being issued with such license. Also, the petitioner herein contends that he had submitted an application dated 27/5/2021 with all requisite documents and a fee of ₹1 lakh for being authorized, for being issued with a IMFL on license at the premises so identified therein. Also, the petitioner submits that the requisite no objections from the various constituents as mentioned in the Act and the rules holding the field were also brought on record. Also, the inquiry as conducted in the matter by the excise authorities had also made recommendations in favor of the petitioner for opening the said IMFL on shop at the premises so identified. Also, the said process not having been taken to its logical conclusion and the license in question not having been so issued to the petitioner, he had instituted the present proceedings. The respondent authorities, the more particular, the Superintendent of Excise, Nalbari, has filed an affidavit in the matter and therein has stated that the application of the petitioner was not so taken to its logical conclusion on account of the fact that the secretary to the government of Assam Excise Department had issued an order, a communication dated 22/10/2021, wherein it was directed that all issue of all IMFL on to तुम्हारा apostrophe का अंदर में रहेगा licenses in Nalbari district be stopped until further orders. Full stop. The petitioner in his reply has in his rejoinder to the affidavit filed by the Superintendent of Excise Nalbari had brought on record a contention to the effect that even after the issuance of the said communication dated 22/10/2021, the authorities were issuing IMFL on licenses in the district on pick and choose basis. Subpara. In view of the above position, Mr. N. Goswami on the last date of listing was required to receive instructions specific to the contentions raised by the petitioner in his said rejoinder affidavit. Mr. Goswami has today placed on record the instructions so received by him in the matter, which reveals that the licenses so contended to have been issued by the petitioner in the rejoinder were so issued much before the date of issuance of the said communication dated 22/10/2021. Accordingly, the licenses in the district, IMFL on licenses in the district of Nalbari being not issued on account of certain objections raised in the matter, this court would not proceed to direct the respondent authorities under such facts and circumstances to issue an IMFL license to the petitioner, IMFL on license to the petitioner hearing. However, considering the contention made in the affidavit filed by the Superintendent of Excise, Nalbari, that as and when the said order is order dated 22/10/2021 is so withdrawn, the application of the petitioner would be revived and the same would be considered in accordance with the Act and the rules holding the field. Also, in view of the above position, the present petition is disposed of, requiring the respondent authorities to consider the application of the petitioner for issuance of an IMFL apostrophe on license in Nalbari at the identified premises as and when the order, the communication dated, the restriction imposed while the communication dated 22/10/2021 is so lifted. Also, however, such consideration would be so made strictly in accordance with the provisions of the Act and the rules governing the field. With the above observations and directions, the petition stands dismissed. A copy of the communication dated 13/8/2024 placed on record by Mr. N. Goswami, furnished by Mr. N. Goswami is placed on records and marked as X.
Orders item 50.
Mr. Roman, what are you waiting for? Huh?
We have petition that item 55.
55 today. 55 today. We'll have Mr. Roman's matter first.
$55.
You have a copy of this judgment, Mr. Roman?
Yes.
Can I just have it? But Mr. H. Roman, Lanak Senior Counsel, assisted by your name?
PWA Majumdar.
PWA Muzumdar, Lanak Counsel appearing for the review petition. Also heard Mr. B. Kaushik, Lanak Standing Counsel, Secondary Education Department, appearing for the respondents number 1, 2, and 3. So, the present review petition has been so instituted. Only have to place this much of it has been so instituted. Praying for review of the order dated 21/6/2024 passed in WPC number 3880/2017 on the ground that the decision of the Honorable Supreme Court in the case of Union of India and others versus Dinanath Shantaram Karekar and others was not considered by this court, while reported in 1998 7 SCC 569 was not considered by this court while passing the said order, review of which is presently sought in the proceedings. Also, the said order, the said judgment admittedly was not considered by this court while passing the order dated so and so. Order dated 21/6/2024, and accordingly, it is contended that the said above admittedly was not considered by this court, and the same was not admittedly considered by this court in the order. What do you have to say?
Your lordships, finding that there are 9, 10, 11 are categorical, my lord, with regard to.
No, only on this. He had placed it. I remember. It was my mistake. I missed it out.
My lord.
So we will review this order. We'll hear the matter today and we'll pass fresh orders accordingly. The Learned Counsel, Mr. B. Kaushik, submits that in view of the categorical statements made in the review petition, that the order, although placed was not considered by this court, comma, I find that it is a fit case wherein the order dated 21/6/2024 is required to be reviewed, and accordingly, the same on review is recalled, restoring the writ petition being WPC number 3880/2017 to file. Also, now, Mr. You can place this.
Since I have delayed the impugned order, that without inquiry, I
Hmm?
can dismiss on the page, annexure 6, page 30, impugned order dismissal.
Page?
Impugned order dismissal.
Impugned order of this.
Page 30.
Page
30.
30, okay.
So without inquiry, without that.
No, that is not the judgment. The judgment is to the extent that it has to be communicated to you. So you show me how it was not communicated.
Because I was not communicated
Because you were not even in India.
No, my permanent residence address, everything.
They had sent.
They are not communicated in the residence.
Can you show me where is your statement that this page 30 was not communicated to you? If you can come to page para 13, page 6. Para 13, page 6. Then you will understand why I did not refer to that judgment. You can come to para 13. Writ petition, writ petition. You have a writ petition?
Yes.
Can you come to para 13, page 6?
Yes, sir. Page 6, paragraph, yes. Another option is that is the humble petitioner stated, board 317 and order was communicated by inspector.
Communicated so and so by which service of was dismissed with effect from 1/6.
Yes. By which
That your humble applicant came to know from the headmaster that's been dismissed from so and so, showing her absence, but the fact the petitioner was working from so and so high school.
Yes.
The attendance register. So you had the knowledge of the order, at least when on 14/4/2017.
But lordship, this order was.
The impugned order is of 4/3/2017.
Yes.
This was passed dismissing you from this date. You had knowledge of that.
Not, but the lordship, it is their duty to communicate.
I know that. I know that. I know that. I know that.
Permanent address in.
Where is that statement?
1/6/19 showing the unauthorized access, but in fact.
The court
it is
does
not.
not say that, the judgment does not say that it is the knowledge or the order received by.
Received by the.
Admittedly,
Received by
this
the-
order was not sent to your home address, but you received it.
No, because it is not communicated to me by any.
Fine,
by anybody.
but but you have received that order from the headmistress.
No, it is unauthorized. access.
That your humble petitioner, last line, that your humble petitioner has collected the copy of the dismissal order from the headmaster of Pugguwahati, so and so, which is not yet communicated, although it has been shown to serve to the petitioner. So at least on the date, which is prior to the date of filing
I
of the
know
writ
order
petition.
From the headmistress, I came to know.
Now,
From the headmistress.
here you come to your decision, subject to correction, just correct me, not if I'm going on a wrong track. If you come to the decision, here para 9.
There are 9 of the judgment says it was respect to the order of the communication. There are 10 says.
And now the reply to that is that paragraph 12 of the affidavit filed by the director. And Mr. Rahman, see the reply that you have filed.
No,
Para 12.
but lordship, paragraph 10 of the judgment, what it says.
No. Judgment gone, reviewed, over. Judgment is gone now. Now we are back to hearing.
No,
We are hearing
no.
only paragraph 12. I'm just trying to understand. Paragraph 12 of the affidavit of the director, secondary education. Have you got it? A second copy to your file. Second copy to you. Give it to no, find that Mr. Kosik, help Mr. Roman. Find that affidavit of yours. Page 37. The last paragraph, paragraph 12. That as regards the statements made in paragraph 13 of the writ petition. Have you got it, Mr.
Yes, sir.
The answering deponent begs to state, if you are feeling some amka, why don't you sit down and argue? You can sit down and argue, no problem. Mr. Roman, be comfortable, please. If it's inconvenient, please sit down. Order of the office so-and-so was also communicated to the petitioner via registered post with a copy to the concerned head of school in respect so-and-so.
Yes.
So this is the contention.
Okay.
Now you come to your reply. That is at page 64.
Yes.
You can consult that, our second file also. One, the first paragraph of para 12, 1, 2, 3, 4, 5, 6 lines from bottom. It starts with the word further. It is submitted that though the dismissal order has been reflected, can be sent to the address reflected in the service book. Then the show cause notices ought to have been sent to the same address and not to the school. This speaks volume about the malafide on the part of the so-and-so. And gone through it, that is why.
But only thing. But
Understand.
if they is communicated by the registered post, whether they have not annexed any receipt.
Mr. Roman.
I know the consequence.
Mr. Roman, you have experience in this side. I think more than many of the persons presently this side.
Okay.
You have much more experience, both state as well as the central, appearing this side. Do you think after so many years these things are maintained? Never.
No, not good. Only thing, Latif, that proper procedure is not maintained because they say that it is communicated, but communication proof is not there. Neither in the registered stamp.
That statement of yours,
Yes.
that this was sent.
Sent.
So why did you not send my show cause? You have not disputed that sending.
No.
If you had disputed that sending, I would have asked them.
They are not paper notification. I got the paper notification. I filed it like reply was not accepted. That's why by registered post I.
Okay. Anything more?
So registered.
I got it. We'll consider that. Don't worry. We'll consider that. We'll consider this judgment also. Anything?
I think that's all, my lord.
Heard the Lanak, heard Mr. Raman, इसमें हाँ, WPC में. Review to dispose हो गया. WPC number 3880-2000. Heard Mr. Raman, Lanak counsel for the petitioner. Also heard Mr. B. Kaushik, Lanak counsel appearing for the state respondents. Also, the Lanak counsels have argued, have made their respective submissions in the matter. Also, hearing concluded. Registry to list this matter again on 5/9/2024 for delivery of orders. I'll not be here for 2 weeks.
I will not here.
When are you here?
I'll go on 19 for Delhi again for.
Check up. Will not trouble you. No. WBC to your restore no. Restore कोई लो ना ताते order did लो. इतो अपने पता ही हो ताते. Into कली करो online. कली कोई नहीं करो ही करो. By yeah, Korofna. Mr. Raman has left. There would be a slight, he says there would be I should not dispose it of today because there will be a technical problem. What I do is I'll ask the registry to list the matter on 16th. If possible, on that day itself, I'll pass the order. Mr. Raman, I'm sorry. I did not know. There may be a technical problem in closing in concluding the repetition today. There would be a problem in concluding the repetition today. Yes. What I do is I'll fix the matter on 16th. You did not be here. Some of your junior, I'll record your name. Hearing, I'll say that on that day concluded. If I can pass the order on that day, I'll pass the order. If not, on 5th. 16th of the repetition में वो सेम ऑर्डर तुम टाइप करके रखना 16 को मार देना और बाकी ऐसा आज के लिए लिखो that list this matter again registry to list the connected repetition on 16/8/2024 for further consideration. Done.
Lordship, in this matter, I have been asked to take instruction and on behalf of the Deputy Commissioner. So already I have gotten instruction that sanction has already been accorded to that ex gratia grant on April last, and it has been sent across to the Revenue and Disaster Management for releasing the amount. So the violation is not there. So Lordship may close this on the.
Mr. S. Burwa, Learned Counsel, appearing for the Mr. S. Burwa, who was requested to receive instructions in the matter from the jurisdictional deputy commissioner as to whether the ex gratia amount claimed by the petitioner hearing was so recommended for payment in terms of the recommended to be so accorded, authorized in terms of the directions passed by this court-wide order dated 26/10/2022 in WPC number 5762/2021. So, Mr. Burwa has placed on record a communication dated 12/8/2024 received by him from the Office of the District Commissioner Kamrup Amingam, wherein it has been highlighted that the ex gratia amount of rupees 4 lakhs only in favor of the petitioner herein has already been accorded sanction, wide sanction letter dated 24/4/2024 and forwarded to the Commissioner and Secretary, Government of Assam, Revenue and Disaster Management for further for release of the amount in question. Also, in view of the said position, the directions as passed by this court, wide the said order dated 26/10/2022 stands complied with. Also, accordingly.
Amount has not disbursed. They are just sanctioned.
Here is may pass and here
Yes,
the
but-
deputy commissioner was to pass a reasoned order
They have also disbursed
Okay.
authority.
and send it to the commissioner.
Yes, Lordship.
That has been done. So order complied with.
But-
We'll make an observation. Don't worry.
Allah.
Full stop. The
Lordship, my humble submission is there, and another case of my matter also, Lordship. They have already sanctioned to the Revenue Department, and contempt petition already closed by this honorable court. And after receive the amount, they are not disbursing. Till 1 year already gone here, Lordship. So if this matter also be closed, they will be pending again.
Okay.
After receiving the.
I'll give you a scope. Don't worry.
Yes.
क्या लिखा है? In view of the said position, the order passed by this, directions passed by this court has been, in view of the above position, this court is of the considered view that the directions passed by this court has been complied with, and accordingly, no further adjudication is called for in the contempt petition. So, however, it is provided that the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department would take the further steps for taking the matter to its logical conclusion at an early date.
But Lordship, in this contempt matter, the Commissioner and Secretary is not a party. So only the Deputy Commissioner is there. And I have entered appearance on behalf of the Deputy Commissioner by way of an Wakalat number.
Commission Secretary is not there.
No, it is only the Deputy Commissioner.
Oh, no. Last line cut.
No. Because that is only with regard to the Deputy Commissioner.
Learning experience. Next time you will not make this mistake.
Lordship.
Next time you will not make this mistake.
Lordship.
You have learned something.
Yes, sir.
We have also learned something that without looking into the cost title, don't pass orders.
Lordship.
A copy of the communication dated खाली वो आगे वाला तक रहेगा close dated 12/8/2024 along with its enclosure is kept on record and marked as X.
51.
Lordship, the petitioner here wants to wants to engage different sets of counsel, Lordship. So we withdraw the Wakalatnama, Lordship, and return back the brief to the petitioner, Lordship.
Then why are you appearing? You leave.
Lordship, 10 days.
When was the brief taken back?
They have decided this morning of
Okay.
received the instruction this morning that
Things happen very proximate to the case being taken up. Why?
this morning they have called us, then they want to engage different sets of counsel. So 10 days time may be given, Lordship.
Raised it to list this matters again after 4 weeks on a date to be fixed by the parties. As prayed for by the learned counsel for the parties, raised it to, yes, Mr.
My little submission, your Lordship. Lordship, otherwise this case don't survive, your Lordship. I can satisfy your Lordship. Your Lordship.
Okay, satisfy me.
Lordship. Lordship, may kindly turn to the order.
Mr.
dated
Singh, the council is in a very precarious condition. He has been asked by his client.
Because we have to go for the press tender, your Lordship. Press tender in this, because I just.
No, we'll have it on 16. Don't
16.
worry.
Oh, okay.
Raised it to list this matter as prayed for by the parties. Raised it to list this matter again on 16/8/2024. Ito iya kore dibo. By slip kore dibo.
Okay.
16/8. You inform.
Lordship.
If they come. Otherwise, I'll vacate the interim.
Lordship. Oblige, Lordship.
And Mr. Singh,
Yes.
be very brief on that.
Yes, it's very small points.
That mati ko. The petitioner in the present proceedings has filed an affidavit, additional affidavit, and therein has brought on record the acknowledgement copies of the service of notice affected upon respondent number 3 and 4. So, accordingly, the service upon the said respondents is held to be complete. So, raised it to list this matter again for admissions after Yes, who is appearing for the Jorat Municipal Board? Jorat Municipal Board, any representation? No. You are appearing, Mr. Goswami.
Name not shown, Doctor.
Okay. He'll hold it. registered to list this matters for admission after 3 weeks on a date to be fixed by.
53.
Here the affidavit is ready, lordship, post it on 22nd. In the meantime, I'll bring on record the affidavit.
As prayed for by Mr. S. Bora, raise the affidavit on behalf of the
Commissioner. My lord, the sole respondent.
on behalf of the contempt.
One time, my lord, sole respondent.
Yes, what is the direction?
The direction was different, my lord, but in the meantime, the calculation was made, my lord. Here, file an affidavit saying I will be satisfied that the amount that is as per the notice, what is the amount due? That calculation has been already been made, my lord, I have to bring it on record.
And dispose of by directing the GMC to undertake verification which would include. Yes. Why have you have made the measurements?
No, that, as per the direction, the measurement have to be taken fresh. A fresh measurement cannot be taken because that in 2021, what measurement has been taken, then no fresh can be done because there are many monsoons has come, again it cannot be. So what is in the record that had to be.
Why don't you file a review petition then?
Well, in the meantime, my lord, in the meantime, that affidavit has come, it has done 30% of that amount will be released. That.
Has he agreed to them?
But that is up to him, my lord. In the meantime, I have to file a record that, because the notice itself, it says 25 to 30% has been completed. And this particular petition has done up to 30%. That is, I have to, if he's not satisfied, you have to go to the civil court too. And then lead evidence.
Okay, you filed that affidavit. Mr. Ember, affidavit on behalf of the sole respondent. Sure. Sole respondent shall be filed within on or before 21/8/2024. Registered to list this matters.
22nd, my lord.
21, I said the affidavit would be filed.
22.
And the registered to list this matters again on 27/8/2024. 28/7/2024. 28.
54.
Please, your lordship. That's not the executive instruction. The direction is 11 also. The content is.
Yes, Mr.
It's to, my lord, turn to page 11 of the contempt petition. That is the part of the order, my lord, which has been complained herein. Lordship will kindly see, my lord, the fact of the case in this was that, my lord.
I'm not of that. The direction is to consider his representation and dispose it of.
An attempt may be made to dispose of the same as expeditiously as possible, preferably within a period of 6 months.
So
now in here, I represent both the respondents. R1 is the principal secretary, R2 is the district commissioner. Both of them had filed affidavit. In the affidavit, my lord, the crux of the affidavit is that, my lord, there are no records available with the authority.
you communicate that to him in a form of an order, that's all.
Yes.
We have not asked you to allow his application. We have only asked you to consider. If you don't have materials, inform that to him. That is the end of the matter.
Yes, that is not. We have duly communicated. Now there are two.
To him?
No, to our clients. My lordship will kindly appreciate two aspects of the matter here. Number one is, my lord, with regard to his deposit, my lord, seeking settlement.
Mr. Bhattacharya, why should we go into? I am only concerned with page 11, last paragraph.
Absolutely. Now here, my lord.
Now you pass an order.
Yes. Now one communication which I have received from the department, lordship may kindly peruse it, my lord. In fact, now the department has constituted a committee, my lord, in order to pass an effective order. That is the difficulty. Because the land is nowhere. Land has gone.
Why are you complicating things?
No, land has gone in Deluvian.
Fine. If that is the situation, you communicate that to him. He will take whatever steps is required to be taken thereafter. Mr. Bhattacharya.
May I please, one?
In the paragraph affidavit in reply, Lordship, paragraph 25, a committee has been formed
No,
to
that is-
reconcile the facts, Lordship.
We are not there. I'm only concerned with the order.
Lordship.
Mr. R. Bapujari, learned counsel appearing for the respondent submits that the respondents be granted 2 weeks' time, within which the order violation of which is so alleged in the present proceeding would be complied with. Also, raised it to list this matters again on 6/9/2024.
Can it be 3 weeks, my lord?
3 weeks, okay.
If lordship is pleased. my
Okay,
lord.
okay. Then list it on 1, 2, 3, 11/9. It will be 3 weeks.
11th of September.
September.
I'm so obliged, my lord.
Just pass that order,
Yes, yes, yes.
reasoned order, that will do.
Absolutely.
Why? There is nothing. Why are you building up a big castle? But our orders, we cannot let it be handled in this manner. It has to be complied with.
I'm obliged.
Wait. The office note dated 26/2024. Service is awaited.
Just 1 month. We'll wait for few days. No, it's 2 months.
Yes, notice was issued on 3/6/2024.
On all the respondents, no?
On all the.
Okay. Await, seen the office note dated 12/8/2024. The service upon respondents number 1 to 6 is not complete. So, raised it to list this matter again after 3 weeks. List this matter again on 9/9/2024, along with a note pertaining to the status of service of notice upon the respondents.
Obliged, sir.
Yes.
It's a petition for substitution of the respondent number 5 to respondent number 5 on his death, my lordship. His legal here has been substituted. Service has been already complete.
What is this miscase number 25 of 2023 in WPC 1452?
Yes,
Is there a miscase here?
Yes, my
Some miscase.
for restoration of the writ petition. The writ petition was dismissed for non-prosecution, my lordship. Therefore, we filed this case for restoration of the writ petition. Wherein we challenge the order of Revenue Board dated 5/3/2012.
What happened? This miscase is for, MC case is for?
For restoration of the writ petition.
Okay.
Number 1452.
Now, we'll have to restore the repetition first. Thereafter only the substitution will come. Prabhat Chandra Malakar is no more. Okay. When was it dismissed for default?
My lordship, page 29, you will see my lordship of the next page. The order dated 29/1/2019. That's my number 5.
Yes. Why were you absent? What is the answer? What is the cause?
My lordship, our mother was taking all the legal.
Huh?
After, at that time, my lordship, this writ petition and everything, as our mother was alive, she was.
No, your advocate. Why did your advocate not appear? Why did you not appear? You are the advocate.
New advocate. my
Why?
lordship. At that time, I was not engaged.
Okay. Whoever, there was a counsel, why he did not appear?
Different set of advocates were there.
Okay, fine. There was a
There
different set of
some
advocates. Why did he
miscommunication, my
not appear?
And the writ petition.
Yes, any objection? Okay. How much? 2 dates, there was no appearance. How much cost?
My lordship, actually, our mother, at the time.
Whoever it
our
is,
mother was,
there was a counsel here. You did not appear. We had to consider this matter 2 days. How much? MC. 10,000.
10,000 is too much, my lordship.
Heard Mr. H.A. Loskar. Right?
SB lordship.
SB Loskar. Learned counsel for the petition. Miss case 25 of 2023. So the present interlocutory application has been so instituted, praying for setting us a recall of the order dated 28/9/20. Recall of the order dated 29/1/2019, passed by this court in the connected writ petition being WPC number 1452/2012, dismissing the same for non-prosecution. Also, the learned counsel for the petition, for the petitioner has submitted that the proceedings in the connected writ petition were being so conducted by their mother. However, on account of old age ailment, she failed to remain in touch. She was not in a position to remain in touch with the engaged counsels on a regular basis. So, it is also but why the advocates have defaulted, you have not put in anything?
There were different sets of advocates.
Who it is, we'll have to know why they did not come.
Maybe some miscommunication between the.
Where is that miscommunication written? Give me a handle, I'll restore it. Also. Yes, what do you say, Mr. Otsaji? What do you say, Mr. Gur?
Did you find an additional affidavit to answer
Bring that here has to be there. Otherwise, nothing is here. The default white occasion, it's not here.
My lordship, paragraph 9 may be seen, my lordship.
Paragraph 9 only says twice dismissed. That's all.
Yes.
The learned counsel for the petitioner submits that he be granted a week's time to bring on record an additional affidavit explaining the reason for which the default had so occasioned in there being no representation on behalf of the petitioners when the matters were called up on 29/11/2018 and 29/1/2019. So, registered to list this matter again. MSIT file. MSIT 25. Registered to the petitioners to file the affidavit on or before 28/8/2024, registered to list this matter again on 2/9/2024. You filed that? We'll see.
Highly recommended. In this regard, for the respondent number 6 and 7, we have taken up for register post as well as dusty matter. I think finally only affected in this regard was only regarding completion of service. So that is.
You have taken dusty.
My lord, I have had an affidavit.
Six and 7. You are paying. The petitioner, by way of filing an additional affidavit, has brought on record the fact that steps upon respondent number 6 and 7 were so taken by way of dusty mode. Also, Mr. M. Sharma, learned counsel, appears for the respondent number 6 and 7. Also, huh?
AU is small finance.
Mr. N. Goswami, learned state counsel, appears for the other respondents. Also, service complete. Registered to list those matters for admission after 2 weeks.
Hearing item 60.
Senior government advocate Dina is in Lake Lords. In court number. Matter may be taken up for some time also.
Where is Miss Yudas? She was director. The records.
Has come lordship from the department.
Department record has come. Okay,
Yes.
we'll see. Before rising, if it come, we'll see. Yeah. Yes.
I would like to draw attention of affidavit filed by the respondents minor, paragraph 22, my lord.
Okay. Hmm. They say they have the power.
They have the power. Under rules 18.2, my lord. I kindly see 18.2, my lord.
Read.
Termination of service grounds 1, 2, 3, 4, 5, 6. 6 grounds are available there. One is misconduct. 18.2 is
Yes,
unsuitability.
SSB rule.
18.2 is unsuitability. They remove the petitioner from service under 18.2 means we have an unsuitability on the ground of death, my lord. Now, my lord, let's examine the rules 26, my lord. What are the procedure prescribed?
You are first referring to 18.2.
18.2.
Mr. Counsel,
My lord,
this is table is for who can terminate whom?
My lord.
So misconduct, also commandant has the power because you are an under officer enrolled person.
My lord.
Unsuitability also he has
Yeah,
power.
my-
So how are you making a submission that this is unsuitability?
My lord.
It can be anything of this.
My lord.
It can be anything, 1 to 6, anything of
But
this.
he was removed under rule 18(2), my lord. 18(2).
Where is the order of removal?
On page number 40.
Page?
Page 40. And 41, last paragraph, my lord. And that was admitted by the respondents in their affidavit, my lord. Paragraph 18, 21, 22, my lord.
Okay. Then they have used power under rule 26.
26, my lord. For misconduct, rules 21 come. For unsuitability, rules 26 come, my lord. Termination of service of enrolled person on the ground of unsuitability, my lord. Where
Okay.
commanding officer, not below
I got
the
it.
rank of commandant, is satisfied that an enrolled person is unsuitable to be retained in force. The enrolled person shall be so informed, furnished with all particulars of all matter adverse to him, call upon to urge any reason he may wish to put forward in favor of his retention. But that procedure was not followed, my lord. We have never supplied this document, never asked.
Where have you asked for that?
My lord.
Where have you contended for that before the authorities? Where is your contention to that effect before the respondents, before coming here? Have you raised this issue before the authorities in your appeal or anywhere?
Actually, start page number 44, my lord.
Nothing is there. You find out. I have seen it. Nothing is there.
My lord, ground number C, my lord.
See. Page?
That page 47. C, F also, my lord.
But that is not what you are arguing now. That is a general statement.
My lord, F also the order removal.
Because the notices were being sent to your house.
That was rejoining notice, my lord, not removal, my lord.
Show cause was not sent. Show cause was not sent.
That was only action for joining, my lord.
The show cause notices were not sent to your house.
No, my lord.
Where, show me. They have said so in the affidavit.
Well, kindly page number 33, my lord. Last paragraph, before taking disciplinary action, you are given last opportunity to resume duty within 15 days. Only for resuming, my lord. Thereafter, they remove me from service, my lord. And that notice were also not served because of he is not available at home, my lord. Moreover, my lord, second paragraph, rules 26, my lord. Before taking disciplinary action, until then, no disciplinary action is there.
Who is appearing for the respondents?
CBSE Dev Chaudhary, my lord.
Huh?
Dev Chaudhary.
Get. We'll hear it in his presence. Hmm? Very typed here, any motor. This is item number 6.
6, my lord.
Raised, heard the learned counsel for the petitioner. None has a counsel for the petitioner who has advanced his arguments in the matter. Further arguments in the matter. Also, the petitioner, the raised to list this matters again on 9/9/2024 for further hearing. Also,
My lord, instead of 9, can it be 11, my lord?
11/9/2024 for further hearing. Yes.
In this case, I was supposed to file that affidavit, this FIR lordship. I couldn't get through, so I need some time for that.
On the prayer of Ms. D. Ghosh. Anything, Mr. Unna?
No, lordship.
On the prayer of Ms. D. Ghosh, learned counsel for the petitioner who submits that she would require further 3 weeks' time to bring on record to comply with the directions passed by this court by order dated 7/6/2024. Prayer is not objected to by the learned standing counsel for the health department. Raised it to list those matters again after 3 weeks, isn't it? 2 weeks, 3. After 3 weeks on a date 2 weeks by. Get that?
This was, we got the news items also, old news items.
No,
I understood.
I just want to get over this.
FIR.
Your other prayers
Yes, lordship.
are it's not specific to your client. It is for the welfare of all.
Yes, lordship.
So we would like to go into that. But
Yes,
first, let us get over
Yes,
this.
lordship. Yes.
26.
Yes, madam.
Lordship, my senior is in lakes, lordship.
Wait. There is an entry order in your favor, no?
No, my lord.
No. Ask her whether that instructions have been received. If not, we will not keep it waiting. We will.
No instruction have been received, lordship.
Okay. Ms. A. Leonard, CGC appearing for the respondents has submitted that the instructions in this connection are yet to be received by him. Accordingly, she prays that the matter be listed on 21/8/2024 on which date?
Day, lordship. She will not be available.
27.
To
Till?
22.
She'll be not available?
From 19 to 22, lordship.
27/8/2024, on which date Ms. Gayan shall invariably bring on record the instructions as with regard to the distance to be maintained from the army establishments for construction of a house. So, let us say 27/8.
28.
Yes.
I could not find out the petitioner's here, lordship. And as per my instruction, it matter pertains to BTC, your lordship, and what by BTC?
Well, consider.
Yes.
Raised it to list, none appears for the petition on call. This Deca, learned counsel, Deca, learned counsel for the
Water issue.
Standing Council Water Resources is present. So, for the ends of justice, raised it to list, matter stands adjourned today. Raised it to list this matters again on 11/9/2024.
34. 35, 36.
Yes, order to
Lordship,
Paisili.
that attachment.
I got it. Wait,
Yes.
just a moment.
Paragraph 17 may be perused, my lordship. That is page 13. May I read it, your lordship?
Yes, any MSCT cases filed in any of these cases?
Yes, MSCT is there, my lord. Earlier it was given, both benefit was given earlier. And against that order, my lord, as per my information, my lord, writ appeal was referred, my lord, and writ appeal admitted, my lord.
Writ appeal is fixed for final hearing, your lordship. Nothing more, no order has been passed beyond that.
Well reasoned judgment.
Yes, your lordship. Item number 35.
It
your
was
lordship.
echoing what my thought process was. We'll follow it. You get it settled in the,
In item 34 and 36, these two are not hit and run case. In item 35, the vehicle is yet to be identified.
vehicle is not identified. So that's a hit and run case. So here in Nasi,
Hit and run, they are, investigation is on, vehicle is yet to be seized.
so 35 vehicle not seized. Number is there? Any particulars?
Final form has been already filed. Your
Huh?
Final, FIR already filed.
Vehicle identified?
No, lordship, FIR
No.
filed.
Where is the FR?
I have not
Police
annexed in
report is
petition,
yet to
but
be
I have
furnished, your
the FIR
lordship.
copy.
We'll adjourn 35, you get your police report. 34 and 36, we are disposing it of in terms of this.
Yes, your lordship.
Show me the FR.
Item 35, your lordship, the government advocate is representing the police department.
If we can make out something, let's see. We'll
Yes.
close it. Who is Sitaranjan Kumar Singh?
Husband of the victim, petitioner. Your lordship.
And the deceased is who?
This
Who
is,
died?
Husband of the petitioner. Your lordship. Sorry, your lordship, there is a three petitioner, my lord.
35 to some.
Item 35, Rani Devi.
Petitioner number 1 is the wife of the deceased, and petitioner number 2 is the mother of the deceased, and
Husband
petitioner number 3 is
died.
the son of the deceased. Oh, sorry.
Who is Chitranjan Kumar Singh?
Chittaranjan Kumar. So, informant, your lordship. As a cousin brother of the deceased, my lord.
Informant.
Yeah.
Okay, here they say
Yes,
that
Lordship.
FR has been done, it's a hit and run case.
Yes.
Deputy Commissioner will make our inquiry and thereafter will forward. Right? Item number
35.
34, 36. The tomorrow yellow.
34.
34 is WPC 507522 and WPC 525422. Yes, what do you have to say?
This one, the appeal is pending, my lord.
No, you go ahead. We are following that. Appeal, there is no stay. This order is binding on me.
Matter that kept pending, my lord.
We'll not keep it unnecessarily pending. If you have any further grievance, you go. You have instituted proceedings before the Motor Claims Tribunal. It's not a hit and run case. So can you be benefited twice?
Earlier it was given, but.
It's a fair compensation that you're going to get in the MSCT court. It's not that you will get something lower. You'll get more.
But earlier.
You can't be. This is public money. Your compensation is being paid, right?
I think he has already got the
Money is paid.
I think
I think
in item 36, I think he has got the amount, your lordship.
Ex gratia amount.
The client is not directly contacted him. I have tried to contact him, but the middleman says that he has already.
Then you withdraw that.
I can withdraw that. In that case, I will.
36. Wait. Now I'll consider your case. You wait. I'll consider your case. Payment has been made. No? You consider. Mr. M.H. Loscott, Learned Counsel for the petitioner submits that the relief as sought for in the present proceedings has been extended to him or her, to him during the pendency of the present proceedings, and accordingly he is under instructions not to press the matter any further. Also, accordingly, the petition stands dismissed for non-prosecution.
Obliged.
Dismissed as having become infructuous. Yes, what is this? What is this?
should I have a copy of the check?
No. One got it. One does not get.
Lordship.
Huh?
Not only one, my lord, all are getting, my lord.
Many have
Least number of
received the ex gratia
date of
amount, your lordship. This order. and
Yours is
judgment,
item number 34.
34.
This is
Heard
dated.
Mr. H.R. Ahmed, Learned Counsel for the petitioner. Also heard Mr. Ms. N. Bordeloi, Learned Standing Counsel, Revenue Department, and Mr. A. Batsaji, Learned Government Advocate, appearing for the respondents, for this other state respondent. So,
Lordship.
I'm with her. There is no state.
raised, yeah?
I'm not for state respondents.
You
I'm
are-
for the revenue.
Or revenue.
For the DC and the. state
Heard
service.
Ms. N. Bordeloi for the Standing Counsel, Revenue Department boss. So, raised it to list this matter again on 9/9/2024.
Obliged.
And where is that? One more 35. But who is appearing for 35?
I'm appearing.
Mr.
S.I. Akan. S.I. Akan.
S.I.
Akan.
Akkan, Learned Counsel for the petitioner. Also heard Ms. You are appearing here?
Yes, your lordship.
N. Bordeloi, Learned Standing Counsel. Revenue Department for respond numbers 1 and 3. Who appear? Who is the government advocate? Nobody. Also.
In
The
earlier occasion, your lordship, P.R. Mahanto.
huh?
P. Mahanto appeared in earlier occasion.
The
Revenue Department.
petitioner in the
Yes,
present
also appeared. Yes,
petition
also.
has prayed for a direction upon the respondent authorities to release, to authorize to him an ex gratia amount of rupees 2 lakhs on account of the death of his,
Oh, women of much.
of Shri, late of, on the death of Abhimanyu Kumar Singh, who was the husband of petitioner number 3,
Petitioner number 1
1,
and 2 is the son,
and 3,
mother.
who is the son of respondent number 3 and the husband of respondent number 1 and father of respondent likhia petitioner petitioner number 2, right?
Yes, that's
Also, as projected in the writ petition, late Abhimanyu Kumar Singh had met with an accident on 15/8/2021 while returning from his working place towards his house situated at Sunapur. Also, at around 10:15 p.m. on the said date, when he had reached Sunapur College Gate, an unknown vehicle had hit him and fled. Also, as a result of the said accident, the said Abhimanyu Kumar Singh sustained grievous injuries in his person, especially a person including head injury. So the injured, the deceased was thereafter, the injured were so and so Abhimanyu Kumar Singh was thereafter taken to Sunapur District Hospital. However, he was declared to have been brought dead, right? So, the petitioner's hearing, being the next of kin of said of deceased Abhimanyu Kumar Singh, had submitted applications before the Deputy Commissioner Kamrup Metro Guwahati, claiming ex gratia compensation in terms of the notification dated 15/11/2014. However, the said application of the petitioners not being considered in the manner required and the amount so due to them not being released led to the institution of the present proceedings before this court. Also, the learned counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that it is a clear case of hit and run, and the vehicle which had hit which had hit late so and so Abhimanyu Kumar Singh has not been identified till date. He further submits that the police, on conclusion of the investigation, had submitted an FR in the matter, wide FR number 451/30/09/2021. Also, in view of the above position, it is the contention of the petitioner that his case is covered by the provisions, by the stipulations made in the office memorandum or in the notification dated 15/11/2014. Okay, I go to the findings 34 today. Issue similar
the proposal would be sent from the deputy commissioner
Okay. Eto tumi kati dia.
department, thereafter the process will be followed.
No, we want an inquiry to be made. That's it. Let it be the commission.
See also.
I'm providing for that. Don't worry. Kili kilo. Principal Secretary. Singh, and if found to be covered by the provisions of the notification dated 15/11/2014, proceed to have the case of the petitioner's hearing processed for release of the ex gratia compensation as due to them in terms of the provisions of the notification dated 15/11/2014. So it is further provided that the principal secretary may have the inquiry caused through the jurisdictional deputy commissioner, and thereafter, on receipt of a necessary report in this connection, proceed further with the matter to examine as to whether the claim of the petitioner hearing is covered, petitioner's hearing are covered by the provisions of the said notification dated 15/11/2014. The above noted exercise be initiated and concluded within a period of 6 months from the date of receipt of a certified copy of this order. 3 months from the date of receipt of certified copy of this order.
Lordship matter in the year of 2001, your lordship, the vaccine was took place.
6 months. 6 months.
Lordship.
They have filed so.
I gave you 3 weeks, 3 months. You said again you started arguing, so I'll go back to 3 months.
I had 10 months, your lordship, I'm sorry.
3 months.
Lordship.
3 months.
Lordship.
So and so. With the above observations and direction, the writ petition stands disposal.
Yeah.
My lord, odd amount 20 lakhs, my lord, principally.
Huh?
20 lakhs liability is there, my lord.
20 lakhs. Okay. How much?
You have segregated the other side.
So around 20 lakhs.
My lord.
Clear that amount. Both Vijaya as well as Cotonox. Heard Mr. A.C. Sharma, Learned Senior Counsel, appearing for the petitioners. Also heard Mr. S. Chamaria, Learned Counsel, appearing for
AIDC, double IDC.
Standing Counsel AIIDC. That is respond numbers 3, 4, 3 and 4. 3, 4 and 5. Also, in the present proceedings, the grievance of the petitioner pertains to
My lord, may I interrupt, lordship? Is it a final order, my lord?
No. Pertains to a communication dated 38/2022 issued by the respondent number 4 requiring the eviction of the petitioner herein from the purported unauthorized occupation of factory shed number 31 bracketed P at Industrial Estate, Tamuni Maidan, Guwahati. Mr. A.C. Sharma submits, Mr. A.C. Sharma, Learned Senior Counsel, appearing for the petitioner submits that there is a dispute with regard to the calculations made by the respondents number 3, 4 and 5 towards the rents due from the petitioner, rents receivable from the petitioner, And also the amounts paid by the petitioners by way of a check was also returned. Also, Mr. Sharma submits that in terms of the directions passed by this court, wide order dated 16/9/2022, an amount of rupees 10 lakhs, bracket words of 10 lakhs, has already been paid, has also already been paid to the respondents number 3 as by way of interim payment of arrear rent. So, Mr. Chamaria on instructions has submitted that as on date, the rents receivable by the petitioner submits that the total outstanding dues as on July 2024 pertaining receivable from Messrs. Bijaya Steel and Wire Products as well as its inheritor, Messrs. Coxton Printers India, works out to rupees round about 64 lakhs. So, Mr. Samaria has submitted that the said amount so receivable also is inclusive of GST, late fine, tax on late fee, bracketed GST, and the same has been so calculated after excluding the interim payment of rupees 10 lakhs so made. Mr. Chamaria has further on instruction submitted that the rent, monthly rent per se receivable from the petitioner in respect of the occupation of the shed by the above noted two, by Bijaya Steel and Wire Products and the petitioner firm works out to get me the amount 2084814, correct?
Right.
Sure. So I'm very expert in maths.
My lord, I'm aiding, my lord.
Works out to 2084,814 lakhs as of end of July?
Yes, end of July.
As of end of July 2024. So, as agreed to by the parties, the petitioner shall, within a period of 10 days from today, pay the said amount of rupees 20,84,814 by way of a demand draft, bracketed DD, bracket overdrawn in favor of the respondent number 3. So, and receive due acknowledgement of deposit of such DD with the respondent number 3. So, if the above payment is so made within a period of 10 days, that is from today, that is within (27/8/2024), because 10 days would be 23/24. I am putting it 20. There is holidays also. 27/8/2024. The same shall be accepted by the respondent number 3 without prejudice. Shall be accepted by the respondent number 3. Also, it is reiterated that the payment so made by the petitioner and also the receipt thereof by the respondent number 3 shall be without prejudice to the claims of either of the parties in the present proceedings. So it is direct, it is also provided that the other components which are required to be so added to the monthly rent receivable from the petitioner, including GST, late fine, etc., shall be so considered on the next date of listing. Right?
Suppose fail to pay, my lord, then at
I'm
least.
coming to that. I'm coming to that.
Yes.
I'm coming to that. In the event the petitioners herein fail to make the payment in terms of the direction herein, passed herein above, within 27/8/2024, the respond number 3 shall be at liberty to evict the petitioner from the premises without any further reference to this court.
Did I appear for the respondents 1 and 2?
Mr.
MD Bora.
appears for the standing counsel.
I appear on behalf of the standing council, MD Bora.
Industry
Industries and Commerce.
Appears for the respondents number 1 and 2. You make that payment,
Yes.
then we will see what can be done.
I do.
Item 40.
Now the bills of Mr. Samaria will be released.
My bill coming, the disturbance for them.
Yes.
But I have gone through it, but I did not get the instruction. I did
Huh?
not communicate my client. Can it
16.
solve my difficulty on
16.
day after tomorrow?
16. As prayed for by Mr. K.M. Alloy, raised it to list this matters again on 16/8/2024.
16. Macho.
File the apni rakhi di book, nalagi. 315.
Yes, sir. But these barriers should be removed, madam. This corona has